Yes. Welcome. Yes.
Well, the notes are ready.
Huh.
Only one in the written notes. If looks at the written notes once, the written note starts from there. It has an annexure A,
Huh.
which are the list of dates.
All right.
By mistake, what we have done is the list of dates. We have put it in the front. What we can do, we can just stitch it, re-stitch it with the list of dates at the back.
Index page number.
Otherwise, the index starts from written notes page 1. Only the list of dates, instead of going to the back, it's come in the front.
Index to top page.
Index is in the first page itself.
First
Covering page.
Oh, very well.
So written notes starts from page 1. Then the list of dates should have gone to the gone at the back instead of
nothing. This is nothing.
You can stitch it.
May I be please allowed to?
Should we stitch it right now and give it to just we'll just do it now and
yes, notice.
Your Lordship,
so
at
least this is perfect, otherwise I don't know what else.
This is for respondent number 1, Your Lordship, for the Calcutta Stock Exchange.
Stock Exchange. Respondent 2 is not valid.
Well, we have already, I appear for respondent 2. We are not required to file.
Well. The written notes of argument filed by the writ petitioner as well as the Calcutta Stock Exchange stock respondent today be kept on record. Hearing is concluded and the matter is reserved for judgment.
I'm very grateful.
But, please do it as early as possible.
Just now, we are doing it, my Lord's officers.
What delay do
Grateful.
Thank you. Yes.
And I appear for the respondent.
Yes, Mr.
I'm being led by
Mr. Chindra.
Pardon?
I'm being led by Mr. Chindra.
Yes, he's there.
Mr. Chindra was to satisfy my lord on the jurisdiction as of section 34.
Yes, my lord.
I may not have to satisfy my lord with respect to jurisdiction of 36.
Yes.
And I will not take much time. Mr. Chindra, perhaps another mistake.
Yes, my lord, I'm here.
Yes, please.
Just give me a minute, my lord.
Yes, absolutely.
I somehow cannot pin this honorable court. So, yes. Yes, my lord.
Yes.
So, my lords, in the last order, if my lords may have a look at the order, my lords had put a specific question to us that how, in the light of section 42,
right,
this is maintainable before this honorable court, provided that another proceeding had been initiated under section 14 prior in point of time before the Honorable Delhi High Court.
True.
My lords, now, just to be clear on the facts, my lords, on law, I will just come on.
What was filed before the Delhi? Section 9?
Section 14, my lords.
Section 14, right.
Section 14.
Yes.
Section 14 was filed challenging stating that the arbitral tribunal is not giving unbiased hearing and so on and so forth.
Right.
My lords, before we proceed on the law, I think, my lords, we have a complete answer on the law and on a singular judgment. But just two facts and 2 sections of the Arbitration Act are going to be material. Before, my lords, before we proceed with the sections, my lords, just on the facts of it, if my lords may just turn to volume 5. And my lords may have a look first at the arbitration agreement. Volume 5, page 561 of the application file.
Yeah. Yes.
561, my lords.
Right, Mr. Yes.
My lords may see 17.2.
Yes.
It says the place of arbitration shall be Delhi or Kolkata.
Yes.
It's not and, my lords.
No.
It is a disjunctive or.
Yes.
Therefore, there was a choice between the parties to choose either this or that.
Yes.
And I will make that good by the proposition of law, my lords, in a judgment which is identical in our facts.
Right.
In fact, Soma is identical on the facts of the matter to us. But I just wanted to place this one, my lords. The place shall be Delhi or Kolkata.
Yes.
Second, Malaj, may please turn to that order of the Honorable Delhi High Court in volume 7 for a minute
Yes.
at page 895. Just to tell Malaj that how the arbitration proceedings were firmly anchored. The seat was in Calcutta, just to tell Malaj what all had happened until that time.
Yes. Yes.
At page 895,
Yes.
Malaj may see this is an order of 8th of July 2014.
Yes.
Malaj may please turn to the next page, 896, para 3.
Yes.
The arbitration proceedings have been progressing before the tribunal since 30th of March 2010. Unfortunately, the presiding arbitrator suffered a heart attack and the proceedings could not be held for a substantial length. However, as things stand, 27 sittings have been held by the arbitral tribunal during this time. The parties have completed their pleadings. The respondent claimant is leading its evidence. The second witness of the respondent is under cross-examination. At that stage, this petition was preferred by the petitioner in May of 2013. So, Malad, substantial progress made. Seat only and only chosen to be Kolkata and no other place, Malad.
Right.
No proceeding happened in Delhi. Nothing akin to a seat, or for that matter, even a venue happened in Delhi.
Yes.
So, Malaj, with these two facts, also, Malaj, just to point to this honorable court, have a look at just in this same volume, Malaj, have a look at para 15 at 898.
Para 15, yes.
The court also said that even if it were to be accepted that this court has territorial jurisdiction, so a territorial jurisdiction point was raised by them, an objection was raised by them. The court doesn't deal with it. The court says even if we assume for it to be so, and then the court said, look, the court said Calcutta also has, you must go to Calcutta. We are not the correct forum. You must go to Calcutta.
Yes. Yes.
Because that's the correct forum. The person appointed there, only the Chief Justice, only the Honorable Chief Justice there knows what's the condition and so on and so forth. And then the petition is dismissed, Manoj, on that point. So having completed this only on the point of jurisdiction, Manoj, having completed this factual basis that the place of arbitration was chosen by the parties to be Delhi or Kolkata, the parties chose Kolkata and no other place. Therefore, Malaj, as per the seat of arbitration, the place of arbitration was firmly rooted in Calcutta, and that would amount to exclusive jurisdiction is going to be my argument, Malaj. And please have a look at the Arbitration Act for 1 minute.
Yes.
And please have a look at section 20. And I'll make that good, Malaj, by 3 judgments of the Honorable Supreme Court.
Yes.
But just have a look at section 20 for a minute.
Yes.
Manoj, may have a look at 20 subclause 1. The parties are free to agree on the place of arbitration.
Yes, obvious. Yes.
So, Manoj, what I'm trying to what I'm going to canvass before this honorable court is the word place of arbitration in 20 subclause 1 and 20 subclause 2 is the seat of arbitration, Manoj.
Yes. Yes.
Please have a look. Failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties. And 20 subclause 3 refers to what is known as the venue, Malaj.
Right.
Which says, notwithstanding anything subsection 1 or 2, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts or parties, or for the inspection of the documents, goods or other property. That's not the case, Malaj. That's nobody's case that it's the venue and therefore becoming. My case is going to be that seat was selected in terms of 20 subclause 1, Malaj.
Yes.
to be Kolkata.
Yes.
And having done so, Malaj, the courts at Kolkata only had exclusive jurisdiction and no other court.
All right. Yes.
And therefore, going to Delhi would not be to the competent court of jurisdiction. And therefore, Section 42 wouldn't apply.
Very well. And you come to section 42 also, there
Yes,
it is
Manoj.
said an application has been made in a court and court has been defined in section 21E
Yes,
to be a
Manoj.
jurisdictional court. So therefore,
Yes, Manoj.
linking the two, you say it has to be a jurisdictional court. Delhi High Court itself will.
Absolutely.
Understood.
Absolutely, Manoj. And in fact, Soma, BGS Soma is the judgment, Manoj, which says the moment a juridical seat is determined,
Yes.
seat is in exclusive jurisdiction irrespective of subject matter jurisdiction. That is what is categorically stated, Manoj.
Right.
So therefore, Manoj, irrespective of what transpired in terms of cause of action or subject matter jurisdiction, the moment a seat is determined, in as much as our cutoff date is 2014 at the max, Manoj, because that is when section 42, according to them or according to the situation, ought to have kicked in. But in my case, Manoj, by that point of time, seat was selected, proceeded without any demur, chosen to be Kolkata.
All the sittings were in Kolkata.
All the sittings are in Kolkata, Manoj.
These are the two first applications in Kolkata. I mean, the 36 and.
Manoj, first was a section 11. First was a section 11 in the honorable in the court at Calcutta.
Very.
My lord, all sittings didn't happen in Kolkata. There were a few sittings which took place in
Jharsuguda.
Jharsuguda
Yeah,
because the claimant's witness couldn't come to.
But then that can be seen as a venue.
Yes,
Yes,
it's more
Manoj.
for a venue.
That was the venue. The reason for traveling to Jharsuguda was for the only reason that a particular witness couldn't come from there to here. Therefore, the tribunal traveled. In fact,
Right.
that is also mentioned in that order of the Honorable Delhi High Court.
All right.
So therefore, Malaj, the argument there is that the moment a seat was selected, it became an exclusive jurisdiction.
Yes.
After that, me filing a petition here, there is of no relevance.
Very well.
Because only the courts at Kolkata had competent jurisdiction. Therefore, it had to come to this court. Having said that, Manoj, may now please turn to the first judgment in the compilation.
And I'll also take note of the fact that section 11 was filed in Kolkata.
Yes, absolutely, Manoj. It was filed in Calcutta. In fact, that is, if Manoj may see it, if I may turn to volume 7, Manoj may have a look at that. Volume 7, page 896.
Very well. Yes.
Manoj may please see at page 896, para 1. The petitioner, however, failed to nominate the second arbitrator. Consequently, the respondent preferred a petition before the Chief Justice of the High Court of Kolkata under section 11 of the Act, bearing arbitration petition number so-and-so, which was allowed on 19th of Feb 2010. The court appointed Mr. So-and-so as the second arbitrator. The two learned arbitrators, namely Mr. So-and-so and so-and-so, mutually appointed Mr. So-and-so as the presiding arbitrator. So this was the first in point of time in 2010, Manoj.
Yes. Yes. Right.
Then a 2014 in Delhi, and then straight away section 34 before this honorable court.
Yes.
Now, Manoj, having put this factual conspectus to be clear, it's uncanny, Manoj, that actually the fact is very close to what happened in BGS Soma. Please have a look at that judgment, Manoj, in my
In fact, the
compilation.
Delhi High Court observation changes the scenario probably.
Yes, Manoj, it does.
Very, very clear on this, and that was the understanding of the party.
Absolutely, Manoj. And Manoj, may please also see as to how the Honorable Supreme Court interprets it.
Yes.
In fact, if I could say, it is quite an identical clause that was there, which was being tested before the court in SGS Soma. Please have a look at that, Manoj, for a minute. Manoj, you have the compilation. It's a small compilation of 3 judgments, Manoj.
The small compilation of 3 judgments. 8? Yes. Yes.
Manoj, may have a look at the first judgment, that is BGS SGS Soma.
Yes.
And in fact, Manoj, the court goes into section 42 and says, when will 42 operate in these circumstances? Manoj, may have a look at that judgment first. Manoj, may please turn straight away to para 3. No, para 2. Manoj, may first look at para 2. Or in fact, para 1, Manoj, may have a look.
Yes.
3 appeals before us raise the question as to maintainability of the appeals under 37 of the Arbitration Act. And given the arbitration clause in these proceedings, whether the seat of the arbitration proceedings is New Delhi or Faridabad, consequent upon which a petition under 34 of the Arbitration Act may be filed dependent on where the seat of arbitration is located. Malaj, may please have a look at the arbitration clause over the page at page 19. Relevant portion. If I can just also read first few lines of para 2. At the outset, as set out as follows. On 16/1/2004, the petitioner was awarded contract for construction of diversion tunnels, coffer dams, concrete gravity in so-and-so 2000 megawatt. The site is located in Lower Subansiri district in the states of Assam. Clause 67.3 of the agreement between the parties provides for the dispute resolution clause. I'm reading Malaj 2.6 at page 19.
Yes.
Arbitration proceedings shall be held at New Delhi stroke Faridabad.
Yes.
In
So
fact,
on.
I am a little better placed, Malaj. In my case, it is clearly an or. Here
No.
it's a stroke. Here it's a stroke which can be interpreted either way.
No, stroke is or.
Or
Yes.
in that case, Malaj, I am similarly placed.
Yes.
Now, Malaj, may please see as to what transpired before the court, how it came up to the Supreme Court. Malaj, may please see para 3. I'm reading from Placetum G, Malaj. Between August 2011 and August 2016, 71 sittings of the arbitral tribunal took place at New Delhi. The tribunal delivered its unanimous award at New Delhi on 26/8/2016, by which the claims of the petitioner aggregating to so-and-so were allowed. On 4/10/16, in view of certain computational and typographical errors, which was rectified in so-and-so, on 3/1/17, the aggrieved party by the arbitral award and the rectification thereto, respondent filed a 34 under section seeking to set aside the awards before the Court of District to the Sessions Judge Faridabad.
Yes.
Then on 28/4/17, the petitioner filed an application under 151 with 710 in 21E seeking a return of the petition filed under 34 for presentation before the appropriate court at New Delhi. In November 2017, after the constitution of a special commercial court, the section 34 petition at Faridabad was transferred to the Gurgaon court. Para 4, Malaj, the Gurgaon court returned it to New Delhi. That challenged in the Honorable High Court, I'm reading Placetum C, Malaj. The impugned judgment was delivered by the Punjab and Haryana High Court, in which it was held that the appeal filed under section 37 of the Arbitration Act was maintainable, and that Delhi being only a convenient venue where the arbitration proceedings were held and not the seat of arbitration proceedings, Faridabad would have jurisdiction on the basis of the cause of action having arisen in part in Faridabad. As a result, the appeal was allowed and the judgment of the Special Commercial Court was set aside. So this is the impugned judgment of the Punjab and Haryana High Court. Then Malaj, may please see over the just one para 9, Malaj, may see.
Yes.
Para 9 at page 22. I'm reading Placetum C. I'm just also outlining what the counsel argued before the Honorable Supreme Court. On the second point, she argued, I'm reading Placetum C. Malaj. On the second point, she argued that the arbitration clause did not expressly state that either New Delhi or Faridabad was to be the seat of the arbitral tribunal. Therefore, the arbitration clause only referred to a convenient venue. And the fact that the sittings were held at New Delhi, therefore, would not make New Delhi the seat of arbitration under 20 subclause 1 of the Arbitration Act. According to her, since the agreements in the present case were signed in Faridabad, and since notices were sent by the petitioner to the respondent's Faridabad office, part of cause of action clearly arose in Faridabad, as a result of which courts in Faridabad would be closed with jurisdiction to decide a Section 34 application. She stressed the fact that BALCO, even assuming that New Delhi was the seat of arbitration, both New Delhi and Faridabad would have concurrent jurisdiction, being a neutral forum in which no part of the cause of action arose, and Faridabad being a chosen forum where a part of cause of action has arisen. When read with Section 42 of the Arbitration Act, since the court at Faridabad was first approached by filing an application under 34, that court alone would have jurisdiction, as a result of which the impugned judgment ought to be affirmed. These were the arguments before the court.
But Mr. Shindra, this is on a slightly different tangential route, because this was Section 34 was the first application here.
Yes, madam. So in fact, I will show there are next two judgments where another application was filed prior to that.
This
And the court
probably would
says-
not be very relevant because this was section 30 was the first. Therefore, section 42 as such, because 42 would not come in. 42 was a wrong argument with utmost respect to her.
No difficulty.
Whoever
madam.
she was.
No,
Yes.
no difficulty. But section 42, they deal with section 42 specifically. Because one of the arguments that is raised before the court is that, look, if you determine seat to be the final, then 42 will be redundant. And the court then deals with it, Malaj. I'll show, in fact, can I show that straight away, Malaj?
Yes, better,
Yes.
good.
Yes. Please have a look at para 59, Malaj. Para 59 at page 55. I just wanted to, before Malaj this, I'll put that point and I can make that good later. Exclusive jurisdiction, Malaj, the court has eventually held that seat is exclusive jurisdiction.
Yes, absolutely.
Yeah.
There is a doubt on that.
Yes.
Otherwise, but if there is a conflict with 42, what will be the scenario?
Yes, Manoj. Yes. Please have a look at that. So, para 59, Manoj. It says, equally incorrect is the finding in Anthrics Corporation that section 42 of the Arbitration Act would be rendered ineffective and useless. Section 42 is meant to avoid conflicts in jurisdiction of courts by placing the supervisory jurisdiction over all arbitral proceedings in connection with the arbitration in one court exclusively. This is why the section begins with the non-obstante clause and then goes on to state, where with respect to an arbitration agreement, any application under this part has been made in a court. It is obvious that the application made under this part to a court must be a court which has jurisdiction to decide such application. The subsequent holdings of this court, that where a seat is designated in an agreement, the courts of the seat alone have jurisdiction, would require that all applications under part 1 be made only in the court where the seat is located, and that court alone then has jurisdiction over the arbitral proceedings and all subsequent applications arising out of the arbitral agreement. So read, section 42 is not rendered ineffective or useless. Also, where it is found on facts that a particular case that either no seat is designated by the agreement or the so-called seat is only a convenient venue, then there may be several courts where a part of cause of action arises that may have jurisdiction. Again, an application under 9 of the Arbitration Act may be preferred before a court in which a part of cause of action may arise in a case where parties have not agreed on a seat of arbitration, number 1, and before such seat may have been determined on the facts of a particular case by the arbitral tribunal under section 22 of the Arbitration Act. In both these situations, the earliest application having been made to a court in which a part of cause of action arises would then be the exclusive court under section 42, which would have control over the arbitration proceedings. For all these reasons, the law stated by the Bombay and the Delhi courts in this regard is incorrect and overruled. So, Balaj, only two scenarios in case of seat of arbitration that 42 will prevail. Number 1, if no seat is determined by the agreement. Number 2, if before determination of the seat, an application comes in one of the forums which has natural jurisdictions. In that case, 42 will govern, Manoj. But the moment the seat is chosen, it is only the court of the seat which will have jurisdiction, and 42 really will not operate in that scenario.
I was actually proceeding on the premise of the second proposition. I mean, on the last occasion when I put the matter for hearing,
Malaj.
I was on the second proposition. I was not aware that already sittings had been held there. Or, I mean, what was the scenario then?
Yes.
How many sittings?
Yeah,
So
enough.
therefore, I thought that there was a conflict. Obviously, section 14, some sittings must have been held.
Right.
If before the seat is chosen, a first
Malaj.
application is made to a different forum, and
Yes.
subsequently the seat is chosen, then the first court will have jurisdiction.
Yes, Malaj, yes.
That was which the proposition on which I was proceeding. But here it appears that seat was chosen, 27 sittings had been held.
Yes, Malaj, yes. Therefore,
And also Delhi High Court held that.
yes, Malaj. Delhi High Court notices that and holds that. And please see, Malaj, how they deal with it about this. In terms of the choice of the New Delhi or Faridabad, how does the Supreme Court actually deal with it? They say that the fact that you have chosen to go to Delhi is that you have selected a seat under 20 subclause 1. It is not even a determination under 20 subclause 2. So, Malaj, may please have a look at that at paras 95 to 99. It is, Malaj, in the end of it.
Yes.
Malaj, may please straight away have a look at 96 for a minute.
Yes.
I am reading from Placitum G. Malaj.
Right.
Applying the Soshua principle delineated above, it is clear that if the dispute was with a foreign contractor under so-and-so, the fact of that the arbitration proceeding shall be held at New Delhi, Faridabad, in clause 6 of 67.3 would amount to designation of either of these places as the seat of arbitration. As a supranational body is to be applied, namely the UNCITRAL rule. As such, arbitration would be an international committee. There being no other contrary indicia, in such a situation, either New Delhi or Faridabad, India's designated seat under the agreement. And it is thereafter for the parties to choose as to in which of the two places the arbitration is finally to be held. Given the fact that if there were a dispute between NHPC and a foreign contractor, 67.36 would have to be read as a clause designating the seat of arbitration. The same must follow even when subclause 6 is to be read with subclause 1 of 67.3, where the dispute between NHPC would be with an Indian contractor. The arbitration clause in the present case states, arbitration proceedings shall be held at New Delhi, Faridabad, India, thereby signifying that all hearings, including the making of the award, are to take place at one of the stated place. Negatively speaking, the clause does not state that the venue is so that some or the other hearings takes place at the venue. Neither does it use language such as the tribunal may meet or may hear witnesses, experts or parties. The expression shall be held also indicate the so-called venue is really the seat of the arbitration. The dispute is to be settled in accordance with the Arbitration Act. Therefore, applies the national body of the rules of the arbitration that is to be held either at New Delhi or Faridabad. Given the fact that the present arbitration would be an Indian and not an international arbitration, it is clear, therefore, that even in such scenario, New Delhi, Faridabad has been a designated seat of the arbitration. However, the fact in all the three appeals before us proceeding were finally held at New Delhi, awards were signed in New Delhi, not at Faridabad, would lead to the conclusion that the both parties have chosen New Delhi as the seat of arbitration under 20 subsection 1 of the Arbitration Act. This being the case, both parties have therefore chosen that courts at New Delhi alone would have jurisdiction over the tribunal proceeding, over the arbitral proceedings. Therefore, the fact that a part of the cause of action may have arisen in Faridabad would not be relevant once the seat has been chosen, which would then amount to an exclusive jurisdiction clause so far as courts of the seat are concerned.
It's like a quantum situation. It's an option. Both are inchoate possibilities. It's observer dependent, party
Yes.
dependent here.
Yes,
So once you choose an option, then it freezes. It becomes a reality.
Absolutely, Manoj. But before the freezing had happened, let's assume a scenario, Manoj, before the freezing had happened, and I would have or they would have moved a
Then
section
42
9.
would apply in its rigor, and then
Yes, Manoj. Yes. So that's the point there, Manoj. And in fact, on an identical scenario where an argument was raised in a wrong application and a section 9(5) was filed prior in point of time is the second judgment, Manoj. May please see that. Page 77.
77, yes.
Yes, this is another judgment, Manoj, by the same
Yes.
bench and perhaps on the same date also, Manoj, if I'm not mistaken.
Oh.
Because they hold it. And Manoj, may please see the factual scenario there over the page at page 78.
No, different date.
I'm sorry, Manoj.
Different date, perhaps.
A different date, yes. Decided on a different date.
Yes.
2020, Manoj. And Manoj, may please see para 2. By an order dated so-and-so, passed by the learned additional judge, district judge presiding cum so-and-so at Gurugram in Arbitration Act, the learned judge, on construing the arbitration clause in the agreement between the parties, arrived at the finding that the seat of arbitration was at New Delhi. Yet by virtue of Balco, since both Delhi as well as Faridabad courts would have jurisdiction as the contract was executed between the parties at Faridabad, and part of the cause of action arose there. And since
Faridabad, you need not elaborate because it relies on Vijay.
Yes, Manoj. Just the factum of it at page 4, at para 4 and 5, there was a previous application filed in the Faridabad courts.
All right.
There the court says it doesn't matter because the court at New Delhi would have. I was just reading it because section 42 was invoked in it at para 2 itself, Manoj. It says, since the Faridabad court was invoked first on the facts of this case, Section 42 of the Arbitration Act would kick in, as a result of which the Faridabad court would have jurisdiction to decide all other applications.
Yes.
Then the court at para 4, Malaj, I'm not reading para 3 again, it's the same point. Para 4, the court says, judgment read as a whole declares that once the seat of the arbitration is designated, such clause has become an exclusive jurisdiction clause, as a result of which only the courts where the seat is located would then have jurisdiction to exclusion of all others. Given the finding in this case, then that New Delhi was the chosen seat of the parties, even if an application was first made to the Faridabad court, that application would be made to a court without jurisdiction. This being the case, the impugned judgment is set aside following SOMA, as a result of which it is the courts at New Delhi alone which would have jurisdiction for the purpose of challenge to the award. As a result of this judgment, Section 34 application that has been filed in Faridabad court will stand transferred to the High Court at Delhi. So even a previous application which was filed in Faridabad was dealt to be filed in the wrong court, and therefore 42 didn't apply.
No, but this is contrary to the second proposition in the previous judge.
No,
That
Malaj.
here it is not clarified whether there were sittings already held, the parties had
In
chosen.
Delhi, Malaj, because Malaj may see it says the courts at because the sittings were happened at Delhi.
What does it say that?
Malaj may please see para 2.
By no,
Gurugram court. It says additional judge, special court at Gurugram, the learned judge construing the arbitration clause in the agreement, arrives at the finding that the seat of the arbitration was at New Delhi.
Oh. Right.
So where the seat of arbitration was New Delhi determined.
It is already determined.
It is already determined. And then it says that even Section 9 would not. Then Malaj may see a little later judgment over the next page. This also, Malaj, is on the proposition that where another application was filed in a domestic arbitration, the court said 42 will not apply. It is only that court which is the court of the seat of arbitration will be the court of exclusive jurisdiction. Now, Malaj, may please have a look at paras. I will not burden this honorable court with the facts. Just the fact that, Malaj, the issue here was not in terms of 20 subclause 1, but the issue here was 20 subclause 2. The arbitrator decided at para 5, Malaj, the arbitrator stated that Panchkula, Haryana is going to be the seat. At para 5 at page 86.
Yes.
Thereafter, Malaj, that arbitrator resigned and another arbitrator resumed charge. And then he said proceedings are going to be held at Delhi. Therefore, the court was determining whether the seat has shifted or not. Whether the seat has shifted from Panchkula to Haryana, Panchkula to Delhi or not. It's in that context it arises, Malaj.
So it says it cannot.
It cannot, Malaj. That's right. That's right.
Right.
Eventually, the court says it cannot do that. And Malaj, it categorically says that in domestic arbitration, Malaj may have a look at para 23.
Right.
I'm reading placitum D, although that proposition is clear, Malaj. In the context of domestic arbitration, it must be held that once seat of arbitration has been fixed, then the courts at the said location alone will have exclusive jurisdiction to exercise the supervisory powers over the arbitration. The courts at other location would not have jurisdiction, including the courts where the cause of action have arisen. As observed above in BGS Soma and Indus Mobile, the moment the parties by agreement designate the seat, it becomes akin to an exclusive jurisdiction clause. It would then vest the courts at the seat with exclusive jurisdiction to regulate arbitration proceedings arising out of the agreement between the parties. I didn't read these paragraphs in Soma, Malaj, because the proposition is
right.
well.
Therefore, there can be three possibilities. One is no seat is chosen, then Section 42 prevails over everything.
Yes, Malaj.
If a seat is chosen afterwards, after the first application is made,
Yes.
then Section 42 also prevails.
Yes, Malaj.
Seat is chosen retrospectively, that court could not be said to have no jurisdiction.
If the seat is chosen, Malaj,
If seat is chosen later.
If seat is chosen later, it's of no significance.
Therefore, if the seat is chosen later, it cannot retrospectively render the first court without jurisdiction.
Denuded it, yes, Manoj, yes.
Denuded. And then obviously the third situation is what we are facing here.
Correct. The third situation, namely, if it is determined, thereafter, there is no scope of operation of Section 42.
Right.
Section 42 would therefore operate only in
Section 42 would actually still operate, Mr. Chindra.
It does, Manoj, but the opposite way.
Yes.
The opposite
because
way.
by reading the definition of court in line with 2(1)(a).
Correct. It would still operate, but
There will be no conflict.
Yes, the consequence of the seat and 42 is going to be the same.
Because obviously court is defined in the act and it uses the expression court. So
Yes.
it has to have jurisdiction.
Yes.
Right.
So therefore, where the seat is determined, Manoj, and in fact,
Right.
Soma is also on the point that where a seat is determined irrespective of a cause of action, even then the seat would prevail.
Yes, that is the, I mean, that is the fun of arbitration. I mean,
Yes, man.
party autonomy prevails.
Absolutely.
And which in a suit it cannot. A third court having no jurisdiction cannot.
Yes,
But parties can choose between two courts, both having jurisdiction.
Yes.
But
So,
in an
Manoj,
arbitration, that is the laxity the parties are having, the
that's
luxury.
absolutely, Manoj. So
Yes.
20, in fact, section 20 subclause 1 is the real party autonomy because it says parties are free to choose.
Yes, 1 is seat and 3 is very no doubt on that.
Yes. So the moment it says free to choose, it is really the party autonomy, and the court then have interpreted that to say that, look, 20 subclause 1 would vest exclusive jurisdiction over everything else.
Otherwise, it's all party autonomy. The question is
Absolutely.
the interplay between this party autonomy and section 42. So
Yeah.
we have resolved that apparently because the three scenarios.
That, yes, Manoj, that Soma is very, very clear. And in fact, Soma is implemented in the next two judgments.
Right.
And in fact, Manoj, in this case, in BBR, there was an application which was filed prior in point of time, which the court said, sorry, it has to go to the relevant court of the seat of arbitration. Therefore, your prior filing 42 will not kick in.
Probably there the seat was not chosen at that point of time when the first
Seat was already chosen, Manoj, by virtue of the order of the tribunal.
No, before the first application.
No, Manoj. Application came afterwards.
The first application came afterwards.
Yes, Manoj. Yes.
But then that is contrary to the second proposition of BJS Soma. BJS Soma says first application comes first, then seat is chosen.
No, Manoj. The seat was chosen in this matter.
That is what you are saying.
Any application came afterwards.
Good.
Yes, that's the point.
So that's all. Yes,
Manoj.
See,
yes, that's on the aspect of arbitration. That's on the aspect of 34.
Only maintainability.
Yes, only on maintainability.
Well, yes.
I'm led by Mr. Bagh. May I start? This is a case of Schrödinger seat.
Schrödinger, I was in my mind, but I've used it in so many judgments, so I did not want to repeat it. Ad nauseam, I've repeated it in so many because we face that situation every day. Schrödinger's cat.
At the outset, I must state,
this is not a cat. This is not so feline. Yeah. Yes.
At the outset, I must state, we had not initially raised this point. Once it had
it had fallen from the court totally.
So I may take issue with some.
You are actually you should support his.
I largely support him. However,
you say 34 is not maintainable.
36 is definitely maintainable. Let me satisfy my lord on that in that regard. May I place just one judgment? 36 does not come under the trappings of section 42. May I just place one judgment in that regard, Milord? This is the case of Sundaram Finance Limited. 2018, 3 SCs. Milord, may I take that copy back, Milord, with the, I'll just hand up a stitched copy. Milord, this very point was considered. If my lord may be pleased to, my lord, come to paragraph 14 at print page 631.
Yes.
Paragraph 14. With my learned seniors, I'll continue with it. We would now like to refer to the provisions of the said Act, more specifically, Section 36, subsection 1, which deals with the enforcement of the award. 36, enforcement, where the time for making an application to set aside the arbitral award under Section 34 has expired, then, subject to provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure in the same manner as if it were a decree of the court. The aforesaid provision would show that an award is to be enforced in accordance with the provisions of the said code in the same manner as if it were a decree. It is thus the enforcement mechanism which is akin to the enforcement of a decree, but the award itself is not a decree of the civil court, as no decree whatsoever is passed by the civil court. It is the arbitral tribunal which renders an award, and the tribunal does not have the power of execution of a decree. For the purposes of execution of decree, it is to be enforced in the same manner as if it were a decree under the said code. Paragraph, if I may skip paragraph 15, my lord may take paragraph 16. Now, this is where the discussion on 42, the interplay starts. If I may please. The line of reasoning supporting the award to be filed in a so-called court of competent jurisdiction and then to obtain a transfer of the decree is primarily based on the jurisdiction clause found in section 42, which reads as under. I'll not trouble my lord, it has already been placed before my lord. If my lord may come to the last paragraph, below Placidum G, the aforesaid provision, however, applies with respect to an application being filed in court under Part 1. The jurisdiction is over arbitral proceeding. The subsequent application arising from that agreement and the arbitral proceedings are to be made in that court alone. Here, my lord, just with relation to arbitral proceedings. If my lord may, paragraph 17, my lord, takes note of section 32, which is termination of proceedings. If my lord may kindly, my lord, take the portion starting after the section is set out. The aforesaid provision provides for arbitral proceedings to be terminated by the final arbitral award. Thus, when an award is already made, of which execution is sought, the arbitral proceedings already stand terminated on the making of the final award. Thus, it is not appreciated how section 42 of the said Act, which deals with the jurisdiction issue in respect of arbitral proceedings, would have any relevance. It does appear that the provisions of the said code and the said Act have been mixed. So, my lord, clearly, once, my lord, the 30 days post the making of an arbitral award have expired, the trappings of section 42 cease, because it ceases to be, my lord, an arbitral proceeding. My lord, if my lord may take paragraph 18, if I may just give a moment of context here, my lord, there were certain conflicting decisions of high courts in this regard. However, the two decisions which found favor by the with the Honorable Supreme Court are dealt with here. Paragraph 18, it is in the aforesaid context that the view adopted by the Delhi High Court in Dalim Industrial Corporation Limited versus Numa Legal Refinery Limited records that section 42 of the Act would not apply to an execution application, which is not an arbitral proceeding, and that section 38 of the code would apply to a decree passed by the court. While in the case of an award, no court has passed the decree. The Madras High Court, paragraph 19, in Kotak Mahindra Bank versus Sivakama Sundari, referred to section 46 of the code, which spoke of precepts, but stopped at that. In the context of the court, thus, the view adopted is that the decree of a civil court is liable to be executed primarily by the court, which passes the decree where an execution application.
That logic should apply to 34 also.
Well, ought not to. 34
is not an arbitral proceeding.
It is in relation to the arbitral proceedings. Once the 30 days expire, 30 days within which the 34 has to be filed.
If arbitral proceeding is to be taken to be the arbitral proceeding literally, the arbitral proceeding before the arbitrator, whenever that award is passed, then arbitral proceedings is terminated as per 32. If this logic is taken, then 34 is after that, and in regular section 96 CPC continuation, appeal's continuation suit, that principle can apply. 34 is not an appeal.
Indeed, my lord, it is not, my lord. However, I submit.
It's a petition under certain specific.
My lord, I submit that
So then also the arbitral proceedings have terminated on 32.
I will show, my lord, from section 34 itself that it has not. Would my lord be pleased to take section 34? I will just refer to one subsection to show that that is not the case.
Sure.
My lord may kindly take subsection 4. If my lord has it.
I do. Yes.
On receipt of an application under subsection 1, the court may, where it is appropriate and so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other actions as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the arbitral award.
Resume means it has stopped.
In hiatus, not necessarily terminated. Difference between terminated and stop. If I may even go, perhaps in perhaps a very naive argument, That's an application for setting aside. Here I'm in an execution petition.
If you say that section 33 is there, even a section
Indeed.
36 is
Indeed.
in jeopardy.
My
32 is not the terminus. 32 is always a hiatus then.
my lord,
It's in limbo
My-
unless it's executed.
my lord, once a 30 days post passing or post my lord, issuance of the award, that is my lord, when the strictures of 42 would cease to apply. That is my submission.
But you see 32.3
My lord.
is come to 32.3.
My lord.
32.3 just defies the logic in Sundaram Finance with utmost respect to the Supreme
My
Court.
lord.
So 32.3 says subject to section 33 and subsection 4 of 34.
My lord.
The mandate of the arbitral tribunal shall terminate with determination. So
Termination
it's
of-
subject to 33 and 34.
My lord, which my lord could be read to mean, my lord, that
36 then is not the terminus. It's subject to those two.
36 my lord 2
The
would
moment
not.
the 34 has been filed,
It has been filed, my lord.
so therefore it's this subject to comes into play, and 36 and 32 does not
My
operate.
lord. My lord, that
Therefore,
would, my
the
lord, be
same logic would apply to 34 and
my lord,
36.
that would, my lord, be, I would say, my lord, that logic would apply to 36(3), my lord, which is the application for stay.
Not only that, 32 itself, 32 is the premise of Sundaram Finance.
My lord.
32 is the premise of Sundaram
Indeed,
Finance
indeed.
holding that
Right.
it's a terminus. So after that, it's not an arbitral proceeding anymore.
Indeed.
So section 42 language is arbitral proceeding.
Yes.
But 32 is not the terminus, but a what should we say? It's in limbo. It's always subject to being reopened by 33 and 34. So by virtue of 32.3, particularly if a section 33 or 34 has been taken out, as in this case,
My lord.
then if 32 termination is subject to this, then arbitral tribunal has mandate.
Well, so these two, my lord, judgment, if I have understood
Sundaram
my lord
Finance-
correctly, my lord, are conflicting. In the sense, if it has
Sundaram
terminated at
Finance
this
is
point,
par incurrium with utmost respect.
I apologize.
Sundaram Finance is par incurrium with utmost respect.
My lord.
Although it's delivered by the Supreme Court.
Hello.
We are bound. That does not mean we cannot say it's par incurrium,
Very well.
as opposed to law. Because the logic in Sundaram Finance is 32. 32.3 is quoted there. 32.3 says it's subject to, the terminus is subject to 33 and 34. Here a 34 has been preferred. Therefore, the arbitral tribunal mandate has not terminated.
Just submit, my lord. Perhaps then those other judgments are following. No, this is an earlier judgment.
Other judgments have followed Sundaram Finance.
My lord, I will just, my lord, confirm that.
If
in
it has followed,
just
I'm not
1 second.
interested. If it has not followed, then I'm interested.
My lord, just, my lord, one moment.
Sorry for being outspoken, but this Sundaram Finance, whenever we start with utmost respect, we mean the opposite, but that's why I'm not
My lord,
repeating
I
it.
will keep that in mind when that is directed at you.
So, but
My lord, I find, my lord.
yes, because this logic is self-contradictory, with due respect.
One, my lord, my lord, 2020 for SEC, my lord, I find, my lord, does not refer to Sundaram Finance.
Cite that.
My lord, interesting. My lord, the judgment cited by my learned
That one,
senior.
yes. Yes.
My lord, those are the conflicting decisions. All are, my lord,
There's no conflict in the
Subsequent.
decisions.
all are subsequent. My lord.
I don't find any conflict in any of these decisions.
My lord, in any event, if my lord, the 34 would lie. So my lord is saying, my lord, then the strictures would not apply to 42 at all. The strictures of 42 would not apply to 34 at all. And therefore, they would not apply to 36 as well. In both cases, my lord, my lord, petition is, my lord, safe.
Let us
May I
come to the
submit this?
language of 42 once.
My lord. May I place it, my lord?
Just let us come to that.
My lord.
That court alone shall have jurisdiction over the arbitral proceedings.
And all subsequent applications.
That is the subsequent
Yes.
applications. But then see, let us continue.
Arising out of the agreement. Agreement
No.
and arbitral.
Yes. And all subsequent applications arising out of the agreement and the
And
arbitral
arbitral.
proceedings.
So not only
So
arbitral
36 and
proceedings,
34 both arise out of the arbitral
out of the
proceedings.
arise
Sundaram
out
Finance
of
is
the
not good.
agreement and arbitral proceedings.
Not good law.
My lord, in any event, my lord,
I can say
Can-
that in my judgment.
in that case, my lord, in any event, my application, my execution petition is
Yours is saved by Mr. Shindra even.
indeed. My lord, in any event, my lord,
But we'll have to deal with this judgment. I love to do this always.
thankfully, my lord, I am not troubled with
No.
that.
In fact, on this judgment, Manoj, there is a judgment by Justice Shampa Sarkar, which relies on this in 2025 on the same logic. So
No.
Manoj may also have to
You have
We'll question the logic and say we are bound. So very well, I'm satisfied on this, and I'm just immediately deciding the jurisdiction point and then proceed with the hearing.
Manoj.
During arguments on the merits of the application under Section 34 of the Arbitration and Conciliation Act 1996, within bracket for short, comma, within double inverted, the 1996 Act, double inverted close, bracket closed, comma, a query fell from the court as to whether the present applications under Section 34 and 36 of the said Act are maintainable before this court, comma, by operation of Section 42 of the 1996 Act, comma, since an earlier application under Section 14 of the said Act had been preferred before the Delhi High Court and decided by it. For sub next para, learned counsel appearing for the petitioner in the application under Section 34 of the 1996 Act cites the following judgments in support of the contention that if the parties choose a particular forum as the seat of arbitration, comma, the courts having jurisdiction over such seat will be the courts of competent jurisdiction. First up, it is pointed out that Section 42 of the 1996 Act uses the expression double inverted court, comma, which, comma, in turn, comma, relates back to Section 2 within bracket 1 within bracket small e within bracket small I of the said Act in a domestic arbitration. And as such, comma, the expression double inverted court used in Section 42 has to be read as the court of competent jurisdiction. Full stop. Learned counsel cites in support of the proposition the following judgments. 18th citation group. Learned counsel appearing for the respondent in the application under Section 34, comma, on the other hand, comma, seeks to argue that although the bar under Section 42 may be applicable to an application under Section 34 of the said Act by operation of Section 42, comma, such fetter FETT here is not attracted in case of an application under Section 36 of the said Act. Full stop. By virtue of Section 32 of the 1996 Act, comma, it is submitted, comma, an arbitration proceeding reaches its terminus with the passing of the award. Full stop. Next para. Section 36 of the 1996 Act provides for enforcement of the award akin to a civil court apostrophe decree, and, comma, as such, comma, takes place only after termination of the arbitration proceeding. First up, coming back to Section 42 of the 1996 Act, comma, it is pointed out that the expression used therein is, within double inverted, that court, C capital, alone shall have jurisdiction over the arbitral proceedings, double inverted close. Full stop. Next para, in support of such contention, comma, learned counsel cites such and such, নামটা দিয়ে দেবেন, Sundaram Finance, comma, reported at, আমি সাইটেশনটা দিয়ে দিয়েছি,
2018 3 SCC
please,
622.
please, reported at 2018 3 SCC 622, where the Honorable Supreme Court, by placing reliance on sections 32, 36 and 42 respectively, came to such conclusion. Full stop. Next para, learned counsel submits that in subsequent judgments as well, the same line of reasoning was followed. Full stop. Next para, upon a careful perusal of the judgment in BGS, SGS, SOMA, sub block Supra, and the subsequent judgments following the same, this court is of the considered opinion that three possibilities have been envisaged by the Honorable Supreme Court in such situations as the present one. Full stop. Next para. First, if the parties do not choose a seat of arbitration at all, Section 42 of the 1996 Act prevails, and the first application in connection with an arbitral proceeding or the arbitral agreement determines the court which has jurisdiction to entertain all subsequent applications arising out of the said agreement or proceeding. Push up next para. Under the second scenario, if the parties have chosen a seat, but after the first application is filed before one of the courts which might possibly have been a seat of arbitration, in such cases also section 42 prevails, and the first court where the application was made would determine the jurisdictional court of the subsequent applications, despite the parties having frozen their choice on one of the possible one of the possible seats, but subsequent to the first application being filed. So next para. In the third scenario, which which fits the facts of the present case, if the parties have chosen one of the two alternative places which were intended to be seats in the arbitration agreement before the first application is filed, the courts having jurisdiction over the seat of arbitration, as chosen by the parties by exercise of their party autonomy, will be the court where court which has jurisdiction to entertain all applications. Full stop. Next para. In such case, the mere fact of the first application having been filed in a different court would be immaterial, for the simple reason that such court would not be construed to be a competent court of jurisdiction as contemplated in section 2 within bracket 1 within bracket small e within bracket small I of the 1996 Act. Which of next para. In the present case, the relevant clause in the agreement between the parties stipulated the place of arbitration to be Delhi or Kolkata. Full stop. Already, prior to the first application being filed before the Delhi High Court under section 14 of the 1996 Act, multiple sittings of the arbitration had taken place and the parties had expressed their choice of seat to be Kolkata. Full stop. Thus, the third proposition enumerated in SGS, BGS, SGS, SOMA would apply, and it is the courts at Kolkata which would have jurisdiction. Full stop. Next para. It is also relevant to mention that even the Honorable Delhi High Court, while deciding the application under section 14, had categorically observed that several sittings had already taken place in Kolkata, and as such, it is the courts of Kolkata which would have jurisdiction. So next para. The said proposition has some similarity to quantum mechanics inasmuch as the choice of the parties remained inchoate, INCHOATE, till a choice was still an option was exercised by them as to which of the two possibilities would be the seat of arbitration. Push up. However, comma, once such once such option is exercised, comma, by choosing the Kolkata courts to have to be the seat, by choosing Kolkata to be the seat of arbitration, comma, the inchoate possibilities became frozen into reality, comma, Kolkata being chosen as the seat of arbitration. For sub next para, with utmost respect, comma, uh, although the judgment rendered in Sundaram Finance Supra is binding on this court under Article 141 of the Constitution of India, comma, some doubt may be raised inasmuch as the logic therein might have a touch of uh, inherent contradiction. First up, I say so with utmost deference, DEFERENCE, since the language used in section 42 is not restricted to the expression ডাবল ইনভার্টের মধ্যে that court C capital, that court alone shall have jurisdiction over the arbitral proceedings, double inverted close, comma, but moves on to mention আবার ডাবল ইনভার্টের মধ্যে and all subsequent applications তারপর আইটালিক্সে arising out of এইটুকুনি আইটালিক্সে বাকিটা আবার প্লেন that agreement and the arbitral proceedings টা আইটালিক্সে আবার নর্মাল shall be made in that C capital court and in no other C capital court. Full stop. Next para. Thus, comma, even applications arising out of arbitral proceedings have been covered within the umbrella provision of section 42. Full stop. Next para. Going by such logic, comma, an application under section 34 as well as section 36 or section as well as section 36 are applications arising out of the arbitral proceedings, comma, despite the arbitral proceedings having already been terminated by dint of section 32 of the 1996 Act. Full stop. Next para. Hence, comma, when faced with a dilemma as to whether the proposition in BGS SGS SOMA, comma, as followed in Hindustan Construction Company Limited Supra and BBR within bracket India bracket closed Private Limited Supra with that of Sundaram Finance Supra, comma, the judgments in BGS SGS SOMA and the two judgments following it are more apt in the facts and circumstances of the case. Full stop. As such, comma, with humility, comma, the principle laid down in BGS SGS SOMA is the one which is required to be followed universally, comma, both in respect of section 36 as well as section 34 of the 1996 Act. Full stop. Next para. Thus, comma, this issue is decided in favor of the applicants in both the applications under section 36 as well as 34 of the 1996 Act. Full stop. This court, comma, thus, comma, observes, comma, that it is this court which has jurisdiction to take up the applications under section 36 as well as section 34 of the 1996 Act pending before it. For some next para, accordingly, learned counsel for the parties are requested to continue with their arguments addressing the merits of the matter. Continue.
My lord does not wish to keep it away.
No, that's why I decided.
My lord.
If you're otherwise situated,
My lord, my learned senior, my lord, wanted to address.
where addressing you can start, don't finish.
Very well.
Let him come at least হয়ে গেছে
Indeed, indeed. My lord, on the last,
এটা যেটা হবে এটা যে এর পরে আসবে যদি কেউ পরে আসে এটা পুরোটা আপনারা করে নিন 2 লাইন হয়তো অ্যাড হবে থার্ড ইন পার্ট আবার দেন
my lord, if I may just,
এটা আপনারা টাইপ করে নিন আন্ডারস্টুড
my lord, if I may, my lord, be slightly pedantic at one point.
one or
my
two
lord,
lines
let me
may be
please-
added later on
My lord, let me please to dictate, my lord, arising out of that agreement. My lord, the section is arising out of the agreement.
oh
I'm being extremely pedantic. I apologize, my lord, but just
Yes.
wish to-
proceed on the merits
My lord, on the last occasion, my lord, I was dealing with, my lord, the points raised with
Yes.
regard to, my lord, the, my lord, challenges which came about to the making of the award.
right
First of which was, my lord, fraud. Fraud in the making of the award on account of, my lord, the arbitrator's alleged mental incapacity. My lord, I had largely finished my, my lord, arguments on facts. I had shown, my lord, one, that the entire argument was based, my lord, entirely on presuppositions and assumptions. I had shown, my lord, that the actual dates, my lord, the sequence of dates would in fact show that, my lord, those presuppositions do not stand. I had shown, my lord, that the conduct, my lord, of my lord, of Kessel's, my lord, was showing a similar modus operandi, my lord, which had in fact, my lord, led to the question of jurisdiction. My lord, I'll not repeat those arguments. My lord.
you have
I,
already repeated those arguments
my lord, I have summarized them. My lord, I have summarized
Proceed,
them.
proceed.
I have summarized. My lord, the last point, my lord, I had to show was, my lord, the documents, my lord, my learned senior friend had shown to show his alleged mental incapacity. Those would in fact show, my lord, a mere at most fleeting observation in the medical records, and my lord would not establish that the arbitrator was unable, my lord, to deliberate, to, my lord, come to think about, to, my lord, arrive at a reasoned award. May I, my lord, straight away,
altered mentation was in the first instance you said
only in the first instance, and that too, my lord, at the time of admission. May I show it? May I trouble? My lord, may kindly, my lord, take, my lord, the supplementary affidavit, my lord, volume 1.
এইগুলো আপাতত সরিয়ে নেওয়া যখন লাগবে না এত করে এটা মেইনটেনেবিলিটির জন্য ছিল তো ওটা হয়ে গেছে yes
My lord, may note, my lord, may kindly take page 10. My lord, this is the discharge summary from, my lord, the first hospital stint. My lord, may note the date. Discharge date is, my lord, 20th May 2020. Admission date, my lord, was 25th April 2020. My lord, where does altered mentation come? My lord, may note, my lord, the first heading after discharge type, admission diagnosis. Admission diagnosis is altered mentation. Next part, my lord, post cardiac arrest status. My lord, the learned presiding arbitrator unfortunately suffered a heart attack. Altered mentation on that date, my lord, would it be a case that altered mentation immediately after heart attack would show that he, my lord, was not in a capacity to pass the award? Once again, my lord, may note this is cardiac arrest. The Delhi High Court, my lord, application based on cardiac arrest. Same modus operandi. Same modus operandi. My lord, page after page, my lord, of these, my lord, may have been placed. May I place, my lord, my lord, the discharge summary of the second stint. So, my lord, the first stint showed altered mentation after heart attack on admission. Not once did it show that such altered mentation was a chronic condition or ongoing. My lord, may take, however, the second stint. Lord, second stint, my lord, is page 15. If my lord may please take page 15. My lord has.
No, you can come to page 11 also.
Grateful.
Please place page 11 also.
My lord.
The last sentence of that.
I am grateful, my lord. I am deeply
That is very important.
presently well conscious, trying to communicate, sitting out of bed, serial CT scans done here. I am grateful, my lord. I apologize for having missed this. I am deeply grateful. So here, not only, my lord, does it not show chronic condition during the stint of hospital admission, but shows that during his stint, he had in fact recovered from that altered mentation. And now, my lord, may kindly take page 15. This is, my lord, the second stint.
Yes.
My lord, may note the date. Discharge date is 20th July. Admission date is, my lord, 14th of June. My lord, may once again take admission diagnosis. Why was he, my lord, admitted? He had, my lord, fever for 3 days, body ache, and generalized weakness with difficulty in passing urine, condom catheter in place under evaluation. My lord, may note one thing missing at the admission diagnosis. Altered mentation.
You seem to be very unhappy for that.
Sorry, my lord.
You seem to be very unhappy for that.
No.
Yes.
This is missing.
So only UTI.
Only UTI and, my lord,
And lower respiratory.
my lord, and when admission is, my lord, taken, the status of the patient is noted.
Definitely.
On the first occasion, altered mentation was noted on that one day. If it were chronic, would, my lord, he not have altered mentation on the day he was admitted for the second time? My lord, may last take, my lord, paragraph, page 18. My lord, may kindly take, my lord, the condition and discharge. This is towards the bottom of the page. My lord has condition and discharge. Hemodynamically and neurologically stable.
What is hemodynamic?
My lord, I believe it's
Something
with
to
the
do with
kidneys.
blood.
With the kidneys, my lord.
Kidneys, actually.
My lord, at least that is check. My lord, that is my recollection. Hemodynamic is with regard to the kidneys. So the presupposition was that he was, my lord, the learned presiding arbitrator was in hospital for 2 stints. In both stints, he was in such a state that he could not possibly have even had one thought of the award. He could not, my lord, have made any efforts towards, my lord, finalizing the award. One,
at least from 28th of May 2020, when he was discharged for the first time,
my lord,
he did not have any problem neurologically or mentally.
My lord, I'd submit merely because that one date of altered mentation is, my lord, shown. That is, my lord, not enough particulars or proof to show that he was, my lord, had altered mentation beyond that date. This is, my lord, a very serious allegation. This is an allegation, my lord, of fraud and effectively, my lord, corruption. Not only must there be particulars, my lord, there must be, my lord, proof, my lord, which is unimpeachable, and that is, my lord, what I will trouble my lord with next, my lord, certain judgments. First, my lord, may I trouble my lord, with a judgment cited by my learned senior. My lord, may kindly take volume 2 of the judgment compilation submitted by my lord Kessels.
ওটাই তো একই জাজমেন্ট এটা দাগিয়ে ফেলেছি অলরেডি ছেড়ে দেবে yes
My lord, may kindly take page 39. This is West Bengal Small Industries Development Corporation versus, my lord, Kaushalya Infrastructure Development Corporation. 2023 SEC Online Calcutta 2-1.
yes
May I trouble my lord to come to, my lord, page 44.
yes
My lord, may kindly take paragraph 22. My lord, I'll place these paragraphs. In Emperor versus Rana Nana Hagavne, AIR 1922, Bombay 99, a division bench of the Bombay High Court, presided over by the Chief Justice McLeod, also differentiated between the words corruptly and dishonestly as included in section 24 of the Penal Code. But court dwelt on using false evidence and defined corrupt as anything which has changed so as to become putrid, vitiated, tainted, and further opined that bribery is not the only cause which leads to corruption. In M. Marasappa versus Krishna Reddy, reported and such and such, the learned single bench of the High Court of Andhra Pradesh at Hyderabad had explained the word corruption to be a wider concept which includes but is not limited to bribery and not trouble. My lord may come to paragraph. My lord may note that when corruption comes into play,
In the last part of the sentence, last sentence,
improper, blameworthy, and any act.
any conduct which is immoral, improper,
Proper, blameworthy, and any act of misappropriation.
Yes.
This is effectively what is being alleged.
Yes. Yes.
Milord may kindly take paragraph 23. Here, Milord, once again, I may note that the judgments cited by my learned, in fact, all the fraud judgments were at the stage of 36.2, 36.3, Milord, unconditional stay, which is a prima facie finding. Milord may note even at the prima facie stage, Milord, the extremely high burden of proof placed. My lord may kindly take paragraph, Milord, 23. The above discussion on the definition of fraud and corruption makes it evident that an award debtor who seeks unconditional stay of an award must discharge the onus of establishing a case prima facie that the procedure resulting in the making of the award warrants undoing of the award altogether on grounds of fraud and corruption. The burden on the party is onerous. It is simply not enough to show that the party was kept in the dark on the appointment of the arbitrator or the proceedings thereafter, that the party was not given adequate effective hearing, or even that there was a breach of the principles of natural justice. Mere surmises, allegations, statements are not sufficient. The burden is onerous. My lord may, I'll not trouble my lord with paragraph 24. My lord may kindly take paragraph 25. The burden which must be discharged would include that the award was obtained by the award holder by concealment.
This is on a different footing. This was intra-arbitration.
Milord, indeed it was. However, Milord, the fact remains, Milord, that there is an onerous burden of proof and the extent of it, I'm sure.
Definitely fraud. Order 6 Rule 4 principle applies.
Indeed.
Applies.
Indeed, man.
No doubt on that. Every court has held that. There will be no court which says that it has to be proved beyond reasonable doubt, as in a criminal case, in fact.
As in a criminal case, even if we take,
although it's preponderance of probability at the end of the day in a civil matter, but even then, high burden.
Even if we take preponderance, my lord, what I have shown, the entire, my lord, foundation of the case is pure conjecture. First conjecture, writing of the award would start only after final written notes. Final written notes submitted barely 3 days before first hospitalization. That is, my lord, first of all, a conjecture, I need not even deal with it. However, I have dealt with it by showing that there are detailed notes of arguments after each sitting. Second conjecture, that prior to all of this, the arbitrators had not discussed amongst themselves or thought at all. I had belied that, showing in fact that those minutes recorded at least some thought process in that regard, that there was in fact 4 months before first hospitalization.
But opinions expressed during hearing.
My lord, this is...
When we hear a matter, we discuss among ourselves, we ask questions.
My lord may say what I'm saying is a conjecture.
But that does not mean that after the hearing is concluded, then also...
That same opinion would carry, absolutely. I'm not saying that. I am, my lord...
To be a conference on the fate of the procedure.
I'm not saying, I am saying, my lord, that from then application of mind had started.
You are right in saying that each of the minutes record all the arguments.
All the arguments, and my lord...
So those could be looked at, and the notes of the arbitrator...
written notes was, my lord, in fact, not
to prepare the award.
In fact, my lord, the minutes were a more accurate recording of what was argued. It was actually what was argued.
Written notes are supposed to be a synopsis.
Sometimes they go beyond. Quite often they go beyond.
No, but even
again, I am going into conjecture.
Synopsis, you say better things were available before them.
Each page shown is mentioned.
Yes.
In those minutes. Foundation goes, here. That is why I'm sure.
Understood. That is the first part.
For completeness, may I kindly show just 2 more judgments. for completeness, my lord, I'll be 50.
Show us any judgment which says that, I mean, what you are saying, which is obvious though.
Surmises and conjecture.
No, not only surmise, it has to be on a much higher pedestal. You must be having judgments which say that fraud has to be proved. I mean,
My lord, let's.
specific particulars have to be pleaded,
lord,
and
that
like
is-
Order 6 Rule 4.
50.
Cite one or two. Don't multiply judgments unnecessarily.
I'm not. That is why, my lord, I
Multiply
started
judgments, I'll choose at my own option, and that may be the worst judgment you are citing.
therefore, for the first.
Whatever I
judgment-
feel, I'll have a pool, have a lottery, and
my lord, they all
take
say
one when it
similar
comes to
things.
judgment. I'm being very clear.
My lord, I'm
So be very careful on what you said. Those have to be the best judgments, the cream of your judgment.
Narayan Chettiar.
If it's the same proposition,
My lord, largely cannot be surmises and conjecture.
particularly in a section 34, no. Only the
My lord, I have
precise judgments.
I have not got, my lord, in section 34 one judgment I'll cite, my lord, in a decree obtained by
No,
fraud.
not that. In a section 34 hearing.
Oh, I apologize.
Yes.
Other side, my lord. My lord, this is 54 LWN, my lord, 606, my lord. This is a Privy Council. My lord, may kindly
It's
take,
exactly what was being said. An allegation of fraud, like in any other charge of a criminal offense, whether made in a civil or criminal. This is precisely what is the law.
my lord,
Must be established beyond reasonable doubt.
my lord.
Yes, yes.
My lord, in fact, I will
Head
just show
note
one
suffice.
paragraph.
Head noting suffice.
Yeah, head note, my lord, just, my lord, 3 lines, my lord.
If you have gone
My
through,
lord, may
yes.
go to my lord, may take the last page of
Burnt midnight oil, so that much should be given to you. Yes.
Great. My lord, may take page 610, my lord,
Yes.
towards the bottom. My lord, the sentence starting with fraud of this nature.
That's the beginning of a
My
sentence.
lord, it's the beginning of the sentence. My lord, 13th line from the bottom.
Page 610.
610, my lord, the last page of this.
Yes, yes, got it.
Fraud of this nature, like any other charge of a criminal offense, whether made in civil or criminal proceedings, must be established beyond reasonable doubt. That is, I had to praise the judge. I am great. I know it is established. I had to satisfy on that point.
You have purchased time for Mr. Bag, let him pay the price now.
Indeed. My lord, one judgment, my lord, just to show, my lord, that surmises, conjectures cannot be used, my lord, to establish fraud. 1976, 1 Supreme Court, page 747. I am relying, my lord, just on paragraph 7. I apologize for the delay. Just fraud.
Yes.
Yeah. My lord has it. My lord may take paragraph 7.
I'm there.
The High Court has carefully considered the various circumstances relied on by the appellant and has held they are not at all conclusive to prove the case of fraud. It is well settled that fraud, like any other charge of a criminal offense, whether made in civil or criminal proceedings, must be
Previous one
established.
quoted.
Yes, I'll quote it. May not make the next sentence. However suspicious may be the circumstances, however strange the coincidences, and however grave the doubt, suspicion alone can never take the place of proof. In our normal life, we are sometimes faced with unexplained phenomena and strange coincidences. For, as it is said, truth is stranger than fiction. In these circumstances, therefore, after going through the judgment of the High Court, we are satisfied that the appellant has not been able to make out a case of fraud as found by the High Court. That is, my lord, precisely my, my lord, case. Once, my lord, there are conjectures and surmises. Even if my lord might feel that perhaps there is, my lord, something rotten in the state of Denmark, that is not sufficient. However, even on facts, I have shown, my lord, that there is nothing rotten in the state of Denmark. Lord, I am led by my learned senior.
We're in a place between the rock and the scissor, my lord.
Who is which?
My lord,
my lord, the other side and perhaps, my lord, the end result, because the difficulty is yesterday, my lord, we were prepared to argue on the point of jurisdiction.
Over
We
now.
thought, my lord, yes, my lord, because I'm told your lordship has delivered the order immediately. So, my lord, on merits,
Yes.
I'm being led by Mr. S.N. Mukherjee, but I'll continue. Lord, may I only do this? My lord, there are 4 points which we are going by. One is the element of fraud, whether, my lord, this element is made out through what is being argued. Because, my lord, we have to look only at the award, the majority award and the minority award. My lord, not even the minority award, because the majority award, essentially, whether it satisfies the, my lord, contours of an award. If it does, then, my lord, nothing else is to be looked into, because the, my lord, premise of a section 34 is limited. Your lordship is, my lord. So only on that point, because what is being argued, first leg which was argued is, my lord, the capacity of the learned arbitrator, which my learned junior has already made the submission on all the points. Is submitted. So I'll not touch upon that point. Next is, my lord, whether the signature is important, and what is, my lord, whether if it is not done at the very first instance, reasons are not given. That is what has happened, my lord. If we go by, my lord, 31.5, may I first read out the section?
Mr. Chadha was arguing on the standard of proof in a fraud.
Indeed.
Fraud allegation. So if you can complete this two judgments have been cited. You can close it here and then move on to 31.
I'll then, my lord, try and encapsulate what judgments have you stated the first time.
Medical aspect has been dealt with.
My lord, I'll not touch upon that. I'll not touch upon that, because that's what is there.
Fully.
My lord, all the documents I'm told my lord junior has shown.
Yes. The 2 discharge certificates and the admission stage of that mental state at the admission stage, full-fledged shown.
So I'll not go.
No need.
All that is being argued, my lord, today, without going into the merits
2
first.
points have been argued by Mr. Chadha. I'm telling you. The first point is that need not be that after the last written note is filed, the arbitrator start this agreement, start writing the award. Yes. And in support of that, he further showed that the minutes vividly recorded, each of the minutes, almost
the submissions are
all
recorded.
submissions,
I'm very,
everything.
very grateful. That's what I would.
Secondly, and that is also cited for the purpose of arguing that the arbitrators, it's not that they did not have any consultation at any point of time. They asked questions, they opined together, their discussion was reflected.
Deliberation is there. That is
deliberation is there, but I somewhat differed from his submission on the account that these deliberations at the time of hearing a matter and deliberation after the conclusion of the hearing for the purpose of the outcome is different, because we confer among ourselves during arguments, but that is somewhat different qualitatively, at least from after the hearing is over and we discuss the judgment, what judgment shall be passed. So there I am not so convinced regarding, but minutes were conclusive and he has made very good arguments on subject to what Mr. Chadha says, Ms. Chinda says, that yes, all the minutes recorded everything. Arbitrators need not have waited for the date of submission of the last written notes. That point has been submitted, and medical point has been submitted, and standards of fraud.
Yes, my learned junior is right in pointing out that another point we had discussed is, my lord, that there was no objection which was ever raised by either of the parties.
Oh, yes.
No objection ever raised.
Yes, absolutely.
But also at the stage
that was raised yesterday.
of
That was
correction,
argued yesterday.
because, my lord, thereafter
not yesterday, the last 2 years.
Thereafter came a stage when, my lord, the award was corrected. Even at that stage, in the corrected
in details, I have
order,
taken notes on that case. And
so there also this point has not been, my lord, ever taken by either of the parties.
33 situation was there, probably.
Yes, my lord. So 33 situation, and thereafter
where it was taken.
Yes,
that
it was
is
stated. They could have taken this objection.
He gave the dates also, actually.
We will, my lord. We will.
He gave the dates, actually.
Oh, he gave.
But that will be in a written notes of arguments.
We will. My lord, list of dates we'll give before we, my lord, indicate all the facts. Now, my lord, on the point. So, my lord, in the you've given till 7, right? Finish this entirely.
2 judgments have been cited on fraud.
2 judgments. And
I've put him on notice that only I'll choose at my will, whichever judgment suits me. I mean, 1 or 2. That will be the worst judgment you are citing.
The 2 different propositions that we have placed them on.
You deliberate among yourselves in 5-10 minutes which judgments you'll be citing.
Lordship.
Very few judgments on fraud. Everybody knows fraud has to be proved on a high pedestal. All of us
that's
here.
Perhaps what we are going to bang
Don't
on, my lord, because that will be our sheet anchor. Otherwise, my lord, if he has not crossed that threshold, then that point really.
You'll also have to cross the threshold of the sheet anchor, the spelling of the sheet anchor. So be careful on citing the judgments. We'll come back in 10 minutes. Yes, okay.
One decision on fraud, and then I'll shift to 31.2.
Yes.
Two 2015, volume 4.
My lord, I've handed off the PDF.
It's okay. It's okay. It's okay. I have it. Soft copy I have. Giving 2 copies. My lord, only one paragraph of this judgment on fraud, paragraph 17, is the last page.
Yeah.
On the facts, my lord, this was setting aside of a decree which was based on fraud. Only the second last paragraph, paragraph 17, last page. It cannot be presumed that the family court in its order dated September 17, 2012, wrongly noted the presence of the appellant husband and the first respondent wife. In fact, this part of the order sheet has not been referred to by the High Court while coming to a conclusion that the appellant husband has played fraud upon the family court as to get a decree of divorce in his favor, merely because the fact that the printout of the cause papers of both the parties have been taken from one and the same computer software, it cannot be presumed that blank wakalatnama signed by the first respondent wife was misused by the appellant husband, or he played fraud and used the same to engage some other senior counsel. This line is important. Such finding of the High Court is not based on evidence, but on mere presumption and conjectures. Why I say so is, my lord, the proof which is required for a fraud has not been made out here. That's all, my lord, on this point of fraud. Lord, on 31.2. May I first read out, my lord, 31.2 once?
Yeah.
Form and contents of arbitral award. For the purposes of subsection 1, in arbitral proceedings with more than one arbitrator, the signatures of the majority of all the members of the arbitral tribunal shall be sufficient, so long as the reason for any omitted signature is stated. So all that is required, my lord, the sufficiency test would be that the reason for any omitted signature is stated. That's the test for sufficiency, my lord. I'll show that the reason has been given. And therefore, this point of 31.2, where, my lord, signatures of the majority members are there and sufficient so long as the reason is given. What is the reason is what I ask myself, my lord. The reason is, if your lordship kindly takes up the prayer, which is, my lord, volume 1, page 42.
Achha, there was a 33 after this.
After this, my lord.
That was signed by all.
That was not only signed, my lord, it was signed by the majority, and the reason is given in that.
That was also signed by majority. 33?
Yes, signed by majority, but it records, my lord, that the other arbitrator is not available, and that is what I'll show. And that he has passed a separate award. Because the reason, my lord, I'm starting from the prayer is, my lord, 33 is the primary challenge. That award, of course, not because of merger. This is the award which now is to be challenged, the corrected award. Now, kindly take up, my lord, page 42, the first prayer
Of the AP.
of the AP, my lord.
Yes.
The first prayer, my lord, set aside the amended arbitral award dated February 22, 2021, including the original award dated July 22, 2020 against the petition.
Has to be.
Has to be, my lord, doctrine of merger. Now, my lord, kindly take
Not
up.
doctrine of merger in that
No,
sense.
indeed. But, my lord,
Yes.
since it's the final
Right.
award.
Merged. Yes.
So 22nd February. Now, my lord, here, may I quickly indicate volume 1, page 46. This is the amended corrected award. The next page, my lord. It's okay. At page 47, may I read out that paragraph? One paragraph. After completion of hearing of the parties, we, senior advocate, third arbitrator and senior advocate co-arbitrator had jointly made and published our award on 22nd July. This will be the first paragraph of page 47. 22nd July 2020. Then senior advocate co-arbitrator had made and published his award separately. Kindly mark this below. So reason is given.
What is the reason?
It is recorded, my lord, that he has made and published his award separately. We, the joint arbitrators, had passed an award of 9 crore 23 lakhs and had also awarded interest at the rate of 10% per annum on the said awarded sum with effect from January 2010. Till the date of award, in page 117 of the award, it was, however, mentioned, and then this part is indicated.
The reasons content has to be the reason for the omission, Mr. Bag.
But here it is my
The
submission
reason
is,
for the omission is not good. It's just blanket. It's just
but
a
it states
blank
that
statement.
he made a separate award that is recorded, and that point was not taken by my learned friends before the, my lord, this is a proceeding which, my lord,
Point not taken is a different issue. But
Lordship.
here we don't find any reason.
reason as to why
Reason as
he
to
was,
why it is,
but not it takes into consideration. Kindly see, my lord, the language once.
This
it may
is
be
just
wrong,
this is a bare statement of fact that this he passed award separately.
my lord,
It does not explain. No reason is given for
as
the
to why
omitted
he has
signature.
passed the order
Omitted
separately,
signature. Not even that. That is also not required. He may want to give a separate award.
my lord.
But omitted signature, you say that this is the reason that
I
he
say, my lord, that
he
this
passed a separate award. That's why his signature was not there.
my signature was not there.
All right.
That's why his signature was not there, and that itself would satisfy the ingredient of 31(2). The sufficiency is, my lord, as long as there is some kind of a reason, some cognizance of the fact that he has passed a separate award. That, in my very humble submission, is, my lord,
But in the third
encompassed in this
arbitrator's
paragraph.
award, Mr. Bug,
Correct.
he categorically stated that he was not consulted on the or something like that.
That's
he
that's
did
the
not.
minority award. Now comes, my lord, the minority award, whether the court is even, my lord, required to look into the minority award. It's only the majority award. And as to why the majority award would not suffice has to be, my lord, culminated from the majority award itself, not the minority award. Today, my lord, if the minority award states reasons in the, my lord, section 34 proceeding, whether the majority award is to be set aside, my lord, the reasons to be culminated in my very respectful submission should be from the award, the majority award, and not the minority award. But if I may sum up the proposition, it would be this, that, my lord, in the section 34 proceeding, where an award is to be set aside, all that the honorable court is required to look into is not even the pleadings. It's only the bare award.
Mr. Bug, the difficulty is this sort of separate awards being written.
My lord.
I mean, in the same award, if we can understand if the dissent is expressed.
Lordship.
But 31 apparently contemplates only one award.
Only one award.
One award.
That's the majority award. That's what my submission is.
That's
because
the-
I'm going to, my lord, today,
So you are saying that the second award is not
not to be
contemplated.
looked into at all. I know. I'll show the judgments later. There are judgments on this point, my lord, that the minority award is, my lord, a non-est in law. Today, if there's a challenge to the award, it has to be a challenge to the majority award. And from a bare reading of the award, whatever the parties are pleading, whatever we have pleaded, whatever, my lord, my learned friends have pleaded, is not even, my lord, required to be looked into in a section 34 proceeding. It's like a order 7, rule 11, my lord, where the plaint is looked into, nothing else. Very similarly, in a section 34, all that the honorable court is required to look into is the section, is the award itself. And by the award, I mean the majority award, not the minority award. Minority award is non-est in law. There are only a few situations when the minority award is to be looked into.
All right.
And when it can supplement, my lord, the reasoning of the court. There are judgments on that line, my lord, as to when a minority award is really, my lord, required to be looked into by the court. This is not one of those situations. In a section 34, all that the honorable court is required to look into is whether the award by itself, if tested on the, my lord, anvil of section 34, the ingredients there.
By dint of section 31(2), you mean to say that the award,
my lord,
quote unquote, is the majority award.
The majority.
If there is a majority award.
Indeed. So whatever reasoning is given, my lord, in the minority award, it is not to be looked into by the court at all.
Very well. the amendment was the amended award was passed only by the two majority arbitrators.
Majority arbitrators, my lord, that your lordship will find at
There
page
is no,
49.
no second opinion on that, we hope.
No, my lord. No, my lord. In fact, my lord, kindly also, this is after 2 hearing. And at page 49, kindly, my lord, note. And I should also indicate, my lord, how the proceeding went. Your lordship will kindly take up the second paragraph at page 47. On or about 21st December 2020, claimant had filed an application under section 33 of the Act, inter alia praying for the following orders. This was our prayer, my lord, in the 33. The first sitting, my lord, this is page 48, the second paragraph, my lord. The first sitting of hearing of the present application was held on 18th January 2021. When pursuant to a prayer for the respondents from the respondent's advocate, a direction was passed to file an affidavit in opposition. I pause here for a moment, my lord. When this direction was passed, my lord, affidavit in opposition, they did not take a point which is now being taken by the respondent by 26 January 2021, and affidavit in reply, if any, to be filed by the
Still,
claimant
we
on
could
this date.
understand that if they had filed the affidavit in opposition, they could have challenged that. But next sentence they say does not wish to file since it's
Does not
formal.
wish to file. That's
That
what I was
point is
coming
not
to.
taken at all.
They have not taken at all when they had the option. They took an opportunity. When they failed, they come and take this point. So they knew. And they have not, my lord, taken the point of 31(2) at all. They can't say, my lord, today that there is no estoppel against law, because that is not the point here. I understand if my learned friend would argue
No,
that
fraud is not.
it can't be, my lord. I am
It's a
very
mixed
grateful.
question, has to be
Very
mixed
grateful. My lord.
Fraud can never be a pure question.
My lord. It's always mixed with the facts, my lord. Always.
Mostly question of fact, in fact.
Indeed, my lord. Indeed. Lordship. Then the next paragraph, my lord. On 29 January 2021, as per the earlier notice, hearing took place virtually. Respondent chooses not to file affidavit in opposition to the said section 33 application. It was submitted by Mr. Ghosh, learned advocate, for the respondent that the respondent does not wish to file any affidavit in the present application, as the amendment as sought for of the award of 22nd July 2020 does not wish to file any application in the present application of amendment. As this was very formal, it was accordingly submitted by Mr. Ghosh that his client does not have any objection in the allowing of the application for the relief as straight. I pause here. Very formal. That does not, my lord, preclude them from taking this point. It's also a formal technical point. And then, my lord, next paragraph I'm not reading, my lord, because that is on the merits of this application. Typographical error is what is held in the first paragraph at page 49. My lord, kindly see the last line. It is recorded that parties have submitted their respective stamp papers. So they have cooperated with the tribunal, my lord. The tribunal being the majority here.
They say that his client does not have any objection in allowing the application for this.
Indeed.
If something is tainted by fraud, I mean, you cannot permit it to be amended.
Indeed. That's my point, and that is why I say, my lord, 31(2) effectively stands satisfied. Because the reasoning is this: they have recorded that there's a separate award. We know. If you have an objection, you take it. No objection given.
All right.
So there is actual compliance in my very humble submission. And my lord, your lordship will then kindly take up.
Mr. Chindra may argue that when the original order was passed, that was signed by both the arbitrators, two arbitrators. In that, there was no reason. But you may counter that by saying that since this merged into that, so two have to be read together and the reason is given.
That's what my argument is, my lord. Because also, that is why I started with the prayer. In the prayer, they've referred to both the amended, my lord, award and the original
their
award.
Prayer is post facto, after the awards are
After
delivered.
the award.
Their prayer cannot invalidate, validate
No, it can't.
invalidate.
It can't. But the second, my lord, corrected award is what, my lord, the first award has merged into.
So the explanation given for non-signing of the third arbitrator in the original award,
my lord,
can be explained in the.
It can be, because it's part of the same majority.
It becomes a part of this.
I'm very grateful. That's my submission, my lord. And hence, non-signing cannot be really, my lord, on facts. And that is where the distinction with Milord Dakhin Bijli Bitaran comes in. Because the facts are different there. This is not Milord the facts in that judgment. It's absolutely different judgment. I'll distinguish it on these facts.
Very.
Yeah. Milord, with this, I'll also contend, Milord, that this 31-2 angle which has been taken cannot be, Milord, in my very respectful submission, a point for setting aside of the award in these set of facts. Because these set of facts, the majority award, whatever is the explanation given, Milord, by the minority, Milord, award, which has been, Milord, delivered separately, Milord, is not to be looked into to assess a section 34 petition. May I, Milord, quickly refer to 29(1), section 29, subsection 1 once.
Yes.
Decision making by panel of arbitrators. Unless otherwise agreed by the parties in arbitration proceeding with more than one arbitrator, any decision of the arbitral tribunal shall be made by a majority of all the members, which stands satisfied here. The only, Milord, stumbling block which perhaps could be, Milord, which has been argued is 31-2. When read in conjunction with 29-1, we are satisfied. It's by the majority. After the reason being given, it is at most a procedural irregularity for which, Milord, today, Milord, the ethos of the Arbitration Act is the speed and, Milord, the efficiency of the proceeding. If we are relegated back again on this technicality, which in my very respectful submission would not, Milord, stand at a stage when this is explained in the majority award. And I call it the majority award because 33 is only amending the original award with a recording that the rest of the award remains the same. That's page 49. So effectively, Milord, it's like a novation under section 62 of the Contract Act. Essentially, Milord, rewriting but telling, Milord, that the entire thing, rest of it will always be the same in the contract. If this is at all, Milord, an irregularity, it will be a procedural irregularity. It is nothing, Milord, more than that. To show the judgments now, or we want to do everything on merits and then come back? Milord, now, I think so. Milord, with this, Milord, I have to now enter into the merits. Milord, may I only pray for this one indulgence? Milord, merits may we come back in the new year and argue. One day, because, Milord, merits will...
The list will collapse, Mr. Bag. Continue.
Milord, then may I, instead of going into the merits, may I start with the judgments on these points? I'll have to, Milord, indicate those judgments because, Milord, on the points which I'm arguing, Milord. With these, Milord, because then on the merits, Milord, I'll kindly permit me to come back and argue on the merits because I'm being led by Mr. S.N. Mukherjee. I'm told, Milord, his on legs. So, Milord, if my learned senior starts on the merits.
Start your arguments on the merits even.
Milord, may I indicate this point? I'll close this point then, Milord.
Do that.
Yeah, show me that, please. Yeah. Milord, may I? Yes.
List collapse.
Have you recorded it here? Huh? Yeah. I'll go from here then.
Because on the last day when this happened, Mr. Bag, the appellate side list also collapsed because they were not expecting.
I apologize, Milord. Today we'll continue, Milord. Absolutely.
Leave something for Mr. Mukherjee to argue.
Merits, Milord, because merits.
Yes. Like your argument in the arbitral proceedings, I may start writing the award and yes.
We are on the proposition of law because I have submitted that, my lord, in a section 34 proceeding, all that the Honorable Court is required to look into is, my lord, the award, nothing else. And that award means a majority award. My lord,
You'll
with
be
this premise,
citing every judgment, Sangyang and
I won't. My lord, I won't.
fed up with those.
No, my lord. Only
Scope of
judgments which
section
say,
37, 34.
my lord, judgments which say that the minority award is not an award in the eyes of law at all.
Absolutely, yes.
Only this, my lord, because
Please.
today I have to first indicate,
Absolutely,
my lord,
yes.
all that. May I only draw this distinction?
Hmm.
My lord, akin to a Order 7, Rule 11, where the plaintiff is to be looked into, nothing else. My lord, in a section 34 proceeding, my lord, it is only the award which is to be looked into, nothing else. By this, my lord, there is also, because there are, my lord, all those catena of judgments where it is held that the evidence cannot be reappreciated. Now, while I say this, my lord, that the evidence cannot be reappreciated, the ambit of the, my lord, documents before the tribunal, which would, my lord, lead to perversity, whether it can be looked into in a section 34 proceeding or whether it cannot be. My lord, today the difference, I may be corrected, my lord, this is what
There's
I
a
was thinking.
difference between reappreciation and setting aside on ground of perversity. We have to look at the evidence either way.
My lord,
You cannot preclude the section 34 court from looking into the
no,
evidence.
it is not.
We have to look into the
Indeed.
evidence to even find out whether there was any
Whether
perversity.
there is any purpose, I am very grateful.
Perversity. For that,
Only for that,
purpose.
only for that limited.
One way, if the tribunal has gone one way,
My lord,
we cannot reappreciate the evidence and find something else.
indeed,
But other points are also taken. You must be addressing those also.
indeed,
That
indeed, I will.
clause of the agreement beyond contract, those arguments are very
That is
relevant.
why, my lord, I was setting the premise, because, my lord, it has been argued by my learned friend, my lord, that it tantamount to rewriting the agreement because the clause in the agreement has not been followed, not been considered. That's the submission, that this has not been considered by the arbitral tribunal. The clause says something. There's
Then
an
warranty
alternate
clause,
indeed.
warranty clause and continuing, what is that? Commencement.
Successful commission.
Commission.
Whether the commission is successful.
These are the two most relevant points.
When, at which point in time, my lord, is that the commissioning has happened?
Commissioning and that successful commissioning. And you'll obviously be stressing on successful and he on commission. It was very obvious from the
But
beginning.
that's the interpretation. Whether
Yes.
that interpretation, if one is given by the arbitral tribunal,
That and the other one is that warranty period.
Warranty period. That's on the merits. So that's what I'm, my lord, perhaps not going
Don't
to
keep
touch
the
upon
entire
today.
thing for Mr. Mukherjee. Unburden him of some of the task.
I'll unburden him of the
Start arguing
judgments
and
on this point.
He'll put the icing on the cake.
I think the merits. I'll continue.
Mr. Mukherjee is not ready in the matter.
He's ready. He's on legs.
Finishes the other matter, he'll come.
He perhaps wouldn't be, my lord, because he'll not be in a position. He'll continue what I'm given to understand in the first half, my lord. So it's stuck.
No, we'll continue in the second half. We are continuing. Up to 3:30 we are taking up.
Matter.
That's why we are so apprehensive of the appellate side list collapsing. Yes. He did on the last Friday. Last Friday or Friday before that.
I'm told he's on legs in an ongoing matter.
Which non-going or ongoing?
Ongoing. Ongoing matter in the second half.
Which court?
Which court?
Ask which court.
Yes, my lord, that's what.
In the meantime, please continue with this.
Yes, my lord, kindly, my lord, I've handed over Hindustan Construction Company Limited.
Tight copies of the judgment, Mr. Bagh. Like Mr. Shindra, if you can just give an index later, not an.
I'll give a compilation. I'll give a proper compilation.
Same things you need not. The copies need not be given, but you can just file a sheet.
I will. With the written notes, my lord, will give everything, my lord.
Yes, only the topics.
Proposition and the judgments on that. And the relevant
paragraphs. And you can give the copies right now.
Indeed.
Yes.
In fact, with the notes, if we will annex it again, so that it will become easier, my lord, we'll also indicate the relevant page numbers in the note.
So the difficulty in that will be I'll be marking here, and so that will be it will be a.
Then we'll give an index. We'll give an index with the page numbers in there. We'll do that.
Yes, we'll keep the copies now and give the index.
We'll do that. Lord, kindly take up paragraphs 31 and 32.
And the last two judgments, the two judgments which have been cited today were on maintainability, so we are not looking into that in our written notes or
it's
in
not
anything.
required.
That's over. Paragraph 30.
The paragraphs 31 and 32.
Right.
In fact, no, this is 2024 volume 2 Supreme Court cases 613. Hindustan Construction Company Limited versus National Highways Authority of India. That you will kindly take up. Here, my lord, Dakshin Haryana Bijli Vitran is considered. That's, my lord, at page 629, paragraph 29, with Russell and Gary Bond being, my lord, quoted in these two paragraphs. 31, may I read out, my lord? In Dakshin Haryana Bijli Vitran Nigam, the court recollected the previous holding in Sangyong, wherein the court had set aside the majority award, but issued consequential directions in the peculiar facts of the case. In Sangyong, this court upheld the view that taken by the dissenting arbitrator in exercise of its powers under Article 142 of the Constitution in order to do complete justice between the parties. The reason for doing so is mentioned in para 77. That is considerable delay which would be caused if another arbitration was to be held. That's exactly what I was submitting, my lord. The entire cost will be, my lord, they'll be burdened with this. This court exercised extraordinary power in Sangyong, keeping in mind facts of the case and the object of expeditious resolution of disputes under the Arbitration Act. However, the court did not, in Dakshin Haryana Bijli Vitran Nigam, direct the dissenting opinion to be treated as an award. In the opinion of this court, that approach is correct, because there appears to be a slight divergence in thinking between Russell and Gary Bond. The former, Russell, is careful to point out that a dissenting opinion is not per se an award. This is, my lord, what I am submitting, but is for the parties' information only and does not form part of the award. But it may be admissible as evidence in relation to the procedural matters in the event of a challenge. So only for procedural matters, which, my lord, gets negated because of the 33, my lord, correction of the award. However, Gary Bond does not expressly say that the opinion is not a part of the award. The author yet clarifies that this is an essential aspect of the process by which the parties have an opportunity to both present their case and hear the reasons for the tribunal's decision. Not hearing the dissent deprives the parties of an important aspect of the process. Now, how it is resolved is the next paragraph, my lord. It is therefore evident that a dissenting opinion cannot be treated as an award if the majority award is set aside. It might provide useful clues in case there is a procedural issue which becomes critical during the challenge hearings. This court is of the opinion that there is another dimension to the matter. When a majority award is challenged by the aggrieved party, the focus of the court and the aggrieved party is to point out the errors or illegalities in the majority award. The minority award or dissenting opinion of the learned authors point out only embodies the views of the arbitrator disagreeing with the majority. There is no occasion for anyone, such as the party aggrieved by the majority award, or more crucially, the party who succeeds in the majority award, to challenge the soundness, plausibility, illegality, or perversity in the approach or conclusions in the dissenting opinion. So this can't be really relied on to challenge the majority award. That dissenting opinion would not receive the level and standard of scrutiny which the majority award, which is under challenge, is subjected to. Therefore, the so-called conversion of the dissenting opinion into a tribunal's findings in the event a majority award is set aside, and elevation of that opinion as an award would, with respect, be inappropriate and improper. This is my submission, Miller, that it cannot be the reason given therein, for whatever reason, Miller, not only on the merits, also the reason for non-signing, non-consultation, that cannot be really looked into while setting aside an arbitral award under section 34.
Even why under 34? Even in SLP or something.
Even in
like
SLP,
that.
can't be.
In a regular civil matter also it cannot be done.
It cannot be.
If a majority decision is the judgment.
My lord.
The minority decision is only a dissenting opinion.
Lordship.
We cannot say that we set aside the majority and substitute with the minority. Then you have to pass your own judgment.
Yes, madam.
You cannot just adopt from that and replace it.
That can't happen. I'm very
That-
grateful.
that-
very grateful.
That
That's
can
what
never
is-
happen.
In fact, Lord, here the reasoning given is which is not being adapted, Lord, for challenging the majority award is drawn from the minority award. That's why my
That-
challenge is
Those can be independent reasonings also.
independently, my lord. If it satisfies the, my lord, the contours of section 34, then yes.
But per se, that cannot be a ground.
First is that I'm very grateful.
Per se, Mr. Chitra was not
He has
doing
actually,
that.
my lord, adapted from
Adapted,
the
yes.
and
He said that
independently argued.
that
Yes,
in fact clues will be found in the dissenting award.
lordship.
But he did not rely on that to say that.
No,
But the
only
other
the reasoning,
aspect remains.
the
Yes.
reasoning.
The other aspect also remains that the aggrieved party is to point out the errors in the majority award. That is only that only has to be seen.
Yes,
No occasion for anyone
No
to
occasion for-
challenge the.
indeed.
Obvious, it's very obvious.
This is 2024, volume 2, Supreme Court cases 613. In fact, also, my lord, this is an important point. I should indicate this. 31.2, the language of the Act does not state that the award will be vitiated by this irregularity. That's not stated here. It's similar today.
No sanction is given.
May I formulate it in this manner?
Hmm.
If it was a penal provision,
That is what no
Then
sanction is
sanction,
given.
very
if
very no sanction is
not
given.
complied.
So today, my lord, if this is not complied with, whether this would then fall within, my lord, 34 is not stated here. So whether this by only the dint of this, whether this will be in contravention with the fundamental policy of Indian law or in conflict with the most basic notions of morality or justice is not given. And 29.1, when read with 31.2, is only a majority award, which has been done here. What happens in law if this is not done? If, my lord, there is no reason given for the omitted signature. That is where, my lord, the gray area lies. It's not stated in the Act. So the question falls for consideration whether the purport of the legislature was that in case it is not signed, no reason given, would it negate the entire award? And would it relegate the parties to the, my lord, rigors of an arbitration proceeding all throughout again? Yeah.
Yes.
On the signed copy, right? Yes. But may I now place reliance on MMTC Limited versus Ostgrain Exports Private Limited. It's a Delhi High Court, my lord, unreported decision. It's unreported, right? Start with paragraph 32. Paragraph 32 of this decision at internal page 14. On the point, this is only a mere irregularity. It can be not, it is not something which would satisfy my lord 34 for setting aside of the award. Paragraph 32, my lord.
Yes.
It is further submitted that Rule 67 of the ICA Rules of Arbitration
This is
states
an
that
international arbitration.
it was, my lord.
No, section 34 has been
No, it's a domestic arbitration. Domestic ad hoc arbitration.
Well,
It is further submitted that Rule 67 of ICA Rules of Arbitration states that in case of 3 or more arbitrators, arbitral tribunal shall sign the award and registrar of ICA shall give notice in writing to the parties regarding paragraph 32, my lord. Has to be institutional, just check. Yes, sir. Institutional. Institutional, my lord. That's why the ICA, that's why, my lord, I stand corrected.
Yes.
The arbitral tribunal shall sign the award and the registrar of ICA shall give notice in writing to the parties regarding the making and signing of the award. In the present case, two arbitrators signed the majority award. That's the facts, Miller. Two arbitrators signed the majority award on 5th March 2021, and one arbitrator signed the dissenting opinion on 16th June 2021 and submitted them to the ICA. The registrar of ICA then notified the parties on 22nd June 2021 about making and signing the award, and in terms of Rule 68A, duly delivered the signed copy of the award to both the parties on 5th July 2021. The arbitral tribunal became functus officio only after 5th July 2021 under Section 32 of the Act on delivery of the signed copy of the majority award and dissenting award together contemporaneously on the same day to the parties. Accordingly, there are no grounds available to the petitioner herein for challenging the instant award on the grounds under Section 34 of the Act. Now, my lord, kindly take up paragraph 47, which is, my lord, page 47. All the judgments are cited before that, my lord.
Yes.
As held in the aforesaid judgments, the arbitral award
Yes, yes.
The arbitral award can suffer from irregularity, but the irregularity cannot be a ground to set aside the award unless such irregularity goes to the root of the matter and shocks the conscience of the court, thus making the award illegal. In the present fact, the procedural irregularities, like some of the orders not been signed by the arbitrator, and one of the
But
arbitrators.
this is on a different footing. Some of the minutes were not signed by the arbitrator.
But paragraph 49.
Yes.
I may just read this part. It's only a few lines
Complete
on the
this,
part.
yes, yes.
And being present during the certain arbitral proceedings are such which do not affect the rights of the parties or cause denial of justice to any of the parties. These irregularities are not such which may affect the decision of the arbitrators. 49, Miller. The court observes that the majority award was signed by the arbitrators passing the majority award on 5th March 2021. And the dissenting award was signed by the arbitrator who was dissenting to the majority award on 16th June 2021. As per the mandate of ICA, the signed copy of the award was delivered to the parties on 5th July on the same by the registrar of ICA. Hence, the same does not suffer from any irregularity.
This is not so German, this judgment. Here, that point is not dealt with as taken by them that the majority award was not signed. No reasons were there.
No reasons were there.
That is not here. And that is not decided here.
This is only for signing.
Signing, there were some
Not
irregularities in
signed
the
by-
minutes. Minutes were not signed by one of the arbitrators, some of the orders. So that's why irregularity was pointed out. It was held that no, since both signed copies, they do not say, Mr. Chinda does not argue that just because the other arbitrator signed a separate award and delivered a separate award, it's bad. He says the majority award does not contain the reasons for not containing the signature of the minority.
Which I have already, my lord, my
That you have
answer is
already
33,
answered. That,
33.
yes.
This is only to draw a parallel with, my lord, the fact that in this matter, my lord, it was decided that if it is not signed by a majority, then, my lord, if it is not signed by the minority.
But here the question is not considered even whether there was any reason or not in that. Might have been a reason
My lord,
given in the majority award.
My lord, may I indicate where? Perhaps it's paragraph 45 onwards, where there's a subheading of procedural irregularity, my lord.
That procedural irregularity was non-signing of one of the arbitrators in some of the awards in the minutes.
Yes, my lord. Procedural, indeed. I
That is
understand. what
entirely on a
is-
different footing.
My lord, it considers the other judgments where, my lord, the facts are given. If
This
the lordship-
judgment by itself is not German in our case. Here there were certain procedural irregularities because some of the minutes were not signed by one of the arbitrators. That is not even their case.
In fact, my lord, there are two judgments referred to in this, my lord, from paragraph 45 onwards.
I'll also refer to two judgments, but that does not make my judgment
No, I understand.
precedent
I
in this
understand what
point.
is following from your lordship. Only to draw a parallel. I'll not press much on this thereafter, my lord. My lord, kindly
This is
take
not
up.
parallel, this is tangential. It's on a different point. Arbitrator irregularity this was a real irregularity, Mr. Bag. Some of the orders or minutes were not signed by one of the arbitrators. Does not vitiate the award at all. Here the only similarity is that the two awards, majority award and minority award,
And
were
the
signed
first one was
separate.
not signed by him.
But it's not decided whether there was any reason in the first award as to why.
That reasoning
That
part
is
is not, my lord.
It is
really-
not a decision on that at all.
Lordship. No, take it. Let's not. Yes. Show me the next judgment.
So you have already gone into the orange zone
Orange,
by
my lord,
citing
red,
this as
red zone now.
no orange because they're going by the ICA rules.
Thankfully, ours is an
I
ad
said
hoc
red.
arbitration, my lord.
Not yet red by citing this judgment. Yes.
Yeah, yeah. Now my lord, may I just encapsulate? I've submitted on 31.2. This is my argument on 31.2, my lord. But this is a mere irregularity, if it is at all an irregularity, because my first contention is 33, the award was corrected, recorded. They've challenged, my lord, the corrected award with the original award. That records, my lord, and that's sufficient reasoning. My lord, 29.1 read with 32, 31.2.
Next page.
Then, my lord, I'm just, my lord, trying to not miss out on any points
These
here,
are
my lord.
Mr. Chadda covered, you covered,
No, my lord,
I also covered probably.
these are the only submissions, my lord, on 31.2. Then fraud, my learned junior has.
Don't worry, I'll keep something for Mr. Mukherjee in the second argument.
My lord,
You make your arguments in your own way.
yes, my lord.
Please, if you run a risk of totally completing, then tell me. I'll just. Before recess, it won't be totally completed.
But before recess, I'll continue. I'll try and continue till then. And thereafter, my lord, I'll seek an indulgence if my learned senior is not there.
Which court?
You've not been able to ascertain.
In Calcutta? This high court?
This is in
Or somewhere
Calcutta.
else?
In Calcutta, my lord. I've met him in the morning. He was leading me in a matter, so I know in Calcutta for sure. My lord,
Tell him that the court is not granting time. Please come at 2.
the next matter. Don't collapse.
One matter for each court. We'll finish that
I'm
matter and
told
come
that
here.
he's on legs, but I don't know. Where is he?
No, give him a call during recess and say that the court is not granting time.
I run the risk of being in the red zone at 2 o'clock then, before your lordship.
You
Then
have
I
some
to
other
enter- No, my lord. Then I have to enter into the merits, which I, my lord.
No, when enter it in the merits. Just before completion, tell me, I'll keep something for Mr. Mukherjee.
My lord. Very well, my lord. Lordship will kindly, my lord. Yeah. Let me go. No, I'll start with the. Kindly grant me one moment, my lord. I have my on the facts. No, this one. This one. You may now give an overview of what, my lord, I'm going to argue on the merits of the matter. I don't want to waste time, my lord, with the fraud angle my learned junior has covered. My lord, I'll encapsulate that in the note. My lord, we had made a total claim of 11 crores in the proceeding, out of which, my lord, we have been granted 9 crores 23 lakhs. So, my lord, heads under which, my lord, our claims was not accepted are 2. On account of cost of new turbine, including erection, commission, supervision, we had claimed, my lord, 1 crore 67 lakhs odd. That was negated completely. The second point, my lord, where we had made a claim was on account of idle charges. We had, my lord, paid for 47 lakhs odd. It was negated completely. Now, my lord, the main issue, which was the subject matter of the arbitration proceeding, was whether the respondent had supplied the turbo generator set to the claimant under the context of the first, my lord, whether they had given it, and the second, whether it was fit to perform in terms of the contract and according to the need of the claimant. That's the commissioning part which comes in, my lord. Now, the tribunal has considered a few facts.
That will be one warranty then.
That will be warranty, my lord. The tribunal has considered a few facts. Date-wise, if I may quickly indicate before I go on to the reasoning and the analysis of the award as to why, my lord, it cannot be, my lord, against the fundamental policy or, my lord, the 34 angle, my lord. Few dates which are important. My lord, when the letter of intent was given, it was on 21st September 2004. Your lordship will then find that the contract is executed on 15 December 2004. I'll give this, my lord, in a list of dates. I mean, the minutes of the joint meeting happened in November 2005. In August 2006, now this is very important, my lord. This meeting, it's at page 781. Tell me the volume. It was held on 22nd November 2005. I'll go through the documents in the second half if your lordship is taking it up, my lord. My lord, 22nd November 2005, there's a defect. The machine was put to test on 6th of August 2006, my lord. This is at the site of the respondent. This was put to test.
Defect was detected on 22nd November.
Defect was detected on 22nd November. This is the meeting which was held. This was discussed there. So, my lord, it was before this.
Yes.
That when it was put to test on 6th of August 2006 at the site of the respondent, it could not reach the full capacity, my lord.
Respondent means you here. Respondent here or them?
Respondent here, my lord. Them. Yes.
They are the petitioner here. So,
Yes, the petitioner here.
So the respondent in the arbitral proceeding.
No, we're here. Vibration was found. I have made this note.
Which place? Kessel's
Kessel's
place.
site or
Is the petitioner here respondent?
my respondent here is us, right?
Yes.
Is that our side?
Our side.
It was at your
Our
side.
Our side. Vibration was found. There's a joint meeting which is thereafter held in Millard, where Kessel's consultant could not identify why this high vibration was happening and why is the machine not reaching the final capacity. That was discussed in this meeting. August 2006, respondent was not ready to deliver to supply a defect-free machine of the claimant. And here, my lord, the other side is the response. So I'll refer to it as Neo and Kessels. That will be better. The Kessels was not ready to deliver this.
No, you said 22nd of November 2005, there was a meeting, joint meeting held.
Where the defect was discussed. This is page 781.
Yes.
It's volume 6, page 781.
781, yes. And what happened on 6th of August? That a test was held. The machine
6th of August, there was a test which the machine was put to.
Are you sure 781? 781 is a different minute.
6th of August.
6th of August, my lord, where this was put to test the machine. And it was found that the machine was
at your place.
At our place. And machine did not reach the full capacity. Thereafter, my lord, responded.
How can it be your place?
My lord, 781 of my volume is a different minutes.
AP, you are on the GA volume?
No, my lord, we are on the AP volume.
Oh, I am also on the AP volume.
I think
then they may be referring to the GA volume.
But kindly grant me a moment. I perhaps.
GA is only 6 volumes, my lord.
Yes, it is 780.
This is the 6th volume they're referring to. Yes, my 781 of AP.
It's a table, my lord.
Yeah, but it's dated 28th of February 2009.
Sure.
You are referring to page 781 of AP?
Of
Yes,
AP.
my lord.
That is, what is that?
Look, that stubborn vibration bearing on 20th of February 09. It starts on the heading.
Here's my page.
Yes.
Not matching. Oh, it's supplementary affidavit, volume 6. I am Lord, kindly forgive me. It's supplementary affidavit, volume 6. Let's check. No, I'll give the pagination later, my lord. Yeah, but the date is not matched. Yeah. But I'll come back to the exact page number. I'll indicate that.
So you make your arguments. What's your argument on this?
Yes, my lord. I'm just indicating the timeline once before, my lord, I come and analyze, because I'll analyze, my lord, the award as to whether the award, the parts of the award, which, my lord, which has been challenged, as, my lord, this reasoning is not enough. They have not taken into consideration the clauses of the contract.
Let us come to that. Why the timeline? If there is any other relevance to the timeline, then you can. Otherwise, you'll put in a list of dates. We'll check from there.
Yes, this minutes. 687. But the page number is 687. And it's in volume.
No, why are you
My-
referring to this particular?
Only for this minute that this.
Why should you
note
take that
the
volume at
machine-
this moment? Yes.
Milord,
Should I take that volume because it's
not
unnecessarily
required, but
cumbersome?
simply giving a timeline, Milord. And
আচ্ছা তাহলে
before
কলমগুলো
that,
এটা নিয়ে নাও
it's not required,
এই
right?
কলমগুলো এখনই আমি চাইলে দেবে
Only to give a premise that it was not, Milord, successfully commissioned on that date. And thereafter, what has happened is the subsequent delivery which has happened, and whether, Milord, because I want to argue the commissioning
Let's
aspect.
first come to the agreement, Mr. Bag, and
My lord.
see what is commissioning from there.
Lordship. Lordship.
What was meant by commissioning
My lord.
there? If there is any clue in the agreement itself.
Lordship.
Where do we find the agreement?
Starts from volume.
AP or G also tell that. Or
AP,
supplement.
Milord, AP.
AP which volume?
But 1139,
Volume
tell
9.
your lordship the
Thanks.
volume.
1139.
It's AP volume, volume 5, it starts at page 554, the contract.
We have come to 1139, so let
No
us
difficulty, Malaz, no difficulty.
1159.
No, not 1139.
59, Milord, 1159. It's marked as Exhibit 5. It's volume 9, page 1159.
Yes. No, Mr. Chinda is right. I was following from the other one. Very well, you will refer to the yet other.
We'll refer to the other.
Please refer to the GA.
I will, Milord.
Because probably either G or supplemented wherever
Gotcha.
it's annexed. Because there's no marking here, so probably I was.
Admit.
What কোথায় ছিল দেখতে হবে কোথায় আছে ওটাই তো হ্যাঁ হ্যাঁ আমরা ওকে বলে দিই supplemented affidavit page 708 please come there.
Lordship. You have it marked.
No, award না sorry agreement কোথায় কোথায় মার্কিং আছে দেখো কোন ফ্ল্যাপ লাগানো আছে যেখানে সেগুলো দেখো
Supplementary of 708 is the award, Milord.
But that's where the
No,
award
that's wrong. I told him erroneously that to give me the award. I want the agreement.
I'll start with the. Here it is.
1159 there also the award is there.
Yes,
The agreement
yes,
is
my
there.
lord. Yes,
Very
my
well,
lord.
let us follow
Agreement
from
is-
আসলে মুশকিল ছিল যে আগে ইয়ে করে থাকি yes
Tell me the exact clause.
where is the commissioning clause or whatever
Milord, can we maybe start with, Milord, clause 2?
yes absolutely.
There's a scope of supply and technical specification. It's at 1162, Milord.
Achha, what is this no
This one. That is fine. Let's start with the agreement. Yeah, we'll come there.
yes true.
Milord, the scope of supply and technical specification starts from 1162.
Hmm.
Schedule 1 referred to, Milord. 2.1. Guarantee parameters as per Schedule 2. Schedule of equipment shall be as per Schedule 3. List of documentation as per Schedule 4. The Lordship will first take, Milord, the guarantee. Milord, it's page 1167. 14.1, Milord.
Successful commission.
For a period of 18 months from the date of successful commission or 24 months from the date of last dispatch of machinery, whichever is early. Well, this is the reason successful commission or 24 months from the last dispatch. I showed, my lord, that is why the dates 2006, it was a failure. It, my lord, did not operate to the full extent. My lord, kindly see the first schedule, which was referred to, my lord, in the scope of supply, is page 1173.
Yes.
The supplier shall design, engineer, manufacture, supply and transport to site with transit insurance, carry out erection, testing and commissioning of one number, the details are given, condensing steam turbine generator set and its auxiliaries schedules 1, 2, 3, 4 annexed to and forming part of this agreement in conformity with the specifications, including clarifications and elucidations laid down therein, and according to the progressive delivery just removing this. An erection schedule to be drawn up by the supplier and approved by the purchasers or consultants so that the plant shall be ready for commissioning and commercial production within the stipulated time of the agreement. The one number turbo generator set shall be suitable for generating total 4.5 megawatts electrical power. And the guarantees clause, my lord, which is page 1196. Lordship kindly takes up 1196 once. The general, my lord, and then the performance clause. But may I first, you're right, 1167, my lord, is where this is shown. Yeah, this is shown.
1167 is
I've
placed.
shown it, my lord. I've just shown it. Yeah, it's shown that. Lordship will kindly take up. Just 1 second. Just 1 second.
There is no dispute regarding the scope of the guarantee, Schedule 2. The ambit of the guarantee. What is guaranteed under this? What
Lordship,
parts or
the
whatever?
performance guarantee. My lord, tests shall be conducted for demonstration of the guaranteed values as detailed hereunder guarantee schedule. And turbine generator system
So
capability
that is all
given.
the systems which were guaranteed.
My lord. And the next, my lord, power consumption of all continuously running equipment. My lord, kindly mark that. That's at page 1197, my lord.
But that is the guarantee.
Yes, my lord. That's the guarantee, my lord.
If that is read into commissioning, then there is no meaning to the guarantee clause.
No, this is, it's
Then if commissioning goes on till
it
it's...
will be, my lord, successful commissioning is what I'm going to argue through this.
Yes, but if you say
That today,
continuously running equipment,
my lord,
if you say that this continuously
If it is
running
once
equipment has to be
started-
read into successful commissioning in the first place,
Hello.
then commissioning would never start. Throughout the period, I mean,
today
it would
if
be
it
eternal.
starts and if it is successful, my lord, till what today if it starts, my lord, successful commissioning stops immediately. Whether that would tantamount to, my lord, successful commissioning of the machine, or whether, my lord, it is
If you
because today,
equate continuously running equipment
my lord,
with successful commissioning itself, commissioning is the starting point.
is the starting point. But today if it
Then the
starts,
guarantee would never start.
Lord, may I humbly submit that is why it
The
states here-
guarantee is once it starts, commissioning is done, successful commissioning is done, then guarantee starts. And this is what is being guaranteed. So
what is being
this cannot be
guaranteed
read
by
into successful commissioning itself. Then the commissioning itself will go on forever
May I
till
submit this?
eternity.
Kindly
It has
take
to
up page-
continuously done for commissioning.
My lord, may I only submit this? Kindly take up page 1196. Kindly see the general part.
Yes.
All equipment shall be guaranteed for workmanship and materials and satisfactory performance. The guarantee for performance shall cover individual items and systems, including electrics, for their ratings or outputs as required in the specifications. Today, my lord, if it starts and if it immediately stops, whether that will tantamount to successful commissioning.
No. There's a difference between successful commissioning and satisfactory performance.
I mean, my lord,
If you read this clause, the guarantee itself, the guarantee commences after successful commissioning, Mr. Bag.
Not
If you read the definition of the guarantee,
my lord.
whatever is guaranteed into successful commissioning, then commissioning will never happen
I understand.
because it will have to continuously run, continuous performance. It will be being
That's
commissioned
the
for
guarantee part.
eternity.
That's for the guarantee part. my lord.
That's the guarantee which is being given
Gotcha.
once it is successfully commissioned.
I get that, my lord.
So the guarantee itself is for continuous performance after successful commissioning. You have to read that into this.
Where is that part? Just show me.
If you read
Unless it
this
reaches
into
the full
commissioning,
system.
commissioning will ever happen because it has to run successfully all through.
The reason perhaps I was showing this, my lord, guarantee schedule is turbine generator system capability. If it reaches this capability, it is then that it's successfully commissioned. If it doesn't reach this
Where do you get
capacity,
that?
well, that's page 1196, my lord, 1, guarantee schedule 1. Turbine generator system capability.
Yes.
Today, if it doesn't reach this capacity,
This
then
was
it is
never
not-
reached.
it was never
Initially, it was reached.
It was never reached, my lord.
Is it your case even?
I will show that. It is below these up, my lord, the optimum limits, which are the requirement, and that is why, my lord, I'll argue that was never commissioned. Yes, definitely. So it could not have started at the first instance. It did not reach the optimum level even once. And that's a case which we have made out. I'll show that, my lord.
All right.
My lord, I'll take your lordship through the minutes. I'll take your lordship through the communications and a tabular chart, my lord, which will show the non-running for 18 months. And thereafter, my lord, I'll show from the depositions, my lord, where this has been dealt with, and my lord, correct. But we have also, my lord, there are correspondences where we have put them on notice that there's never a complete thing. You've never started it, and hence, my lord, the basic fundamental, my lord, breach is on your part. And that's the basis of, my lord, the proceeding. And that comes from the, my lord, correspondences. There is a chart where, my lord, I'll take your lordship to that chart. It's in 2007, where the problems were all charted, my lord. Minutes have been held where we have, my lord, indicated this defect. Turbine failure report is on record. The report on rectification leading to, my lord, this machine was also given. And I'll show from, my lord, the non-continuous running of the machine has also been charted. That this is not, so today, my lord, if they say it's commissioning, whether it will mean that if I started, if the car is not able to, my lord, run for, my lord, the full throttle, the full force, that would not, my lord, tantamount to a successful commissioning. It's only so the difference between, my lord, successful commissioning, which is the point where the guarantee will start. Once it has not reached that point, the guarantee would never start. Lifespan of the machine was for 25 years, and that is, my lord, where if it doesn't start successfully in the first instance, it cannot be, my lord, argued that there was, my lord, the guarantee clause would come into operation. And this is not, my lord, something which we are submitting from the bar. It's there on record. All these are through correspondences which are contemporaneous, my lord, documents, which I'll show. Now, my lord, may I? My learned junior tells me that I've taken instruction. I found out that the next matter will go on. They are all ready. So we can come back after vacation. This code, my lord. They are all ready. So he said,
is there. He is supposed to be available at 2 o'clock. That is
so, my lord, that is our saving.
No, we'll ascertain and after recess, and you be there after
I'll
recess.
go back, my lord, and I'll just hope.
You be there after recess. Only if you'll be kept in captivity. Only if the other matter is ready, then we'll
We'll
Yes.
make sure that, my lord, we find
I'll
Yes.
find
Either find Mr. Mukherjee or find the
Mr. Banerjee. We'll
Mr. Bhatt
which
can
Mr.
get
Banerjee?
hold of Mr. Shuddha Banerjee from the
Either get hold
library.
of Mr. Banerjee, which will be easier than Mr. Mukherjee probably.
I'll do that, my lord, immediately. But maybe come back then after vacation. I'll be here at 2.
No.
I'll be here
We
at
decided
2.
2. That will decide at 2.
Yes, ma'am.
এটা থাকবে, এটা কন্টিনিউ করবো।
been successful in my brief. I've got him, my lord. That was my
Extremely unsuccessful.
we've got him in the court, my lord. So
You're reading the next matter.
Let him do it. Not he's addressing your lordship. He's on leg.
my lordship, I've indicated my
No,
difficulty.
if you're ready, Mr. Banerjee will take up to you.
Very grateful, my lord. I'll come back in January. I'll argue.
Not ready, he says.
Not ready.
Continue then.
Bolo da, Tony, bag, please.
But may I only seek this indulgence? May I come back in January and argue, because I'll be wasting the court's time, and I don't want that. I'm not very ready on the merits, my lord, until unless I'm
যেটা আগে বলেছিলাম মেইনটেনেবিলিটি সকালে তারপরে প্যারাগ্রাফ heard in part who establishes the matter for further hearing on 9th January or 2nd January, whichever suits you.
My lord,
Tony.
9th.
the 9th.
We are putting it on,
My lord, conclude on that. 9th January, my lord.
Mr. Chinda, we are putting it on 9th January.
Could my lord just give me one moment, my lord, just to
Is
see.
16th, but I'm told Mr. Mukherjee will not be there on 9th. But may I pray for 16th? We'll conclude on that.
That will be too late. It's a
Too late.
part-heard matter.
Then my lord, 9th. 9th, my lord, will argue.
Yes, Mr. Chinda, what is your?
Just give me one moment, my lord, just one. My lord's 9th is fine.
Please the matter on January 9, 2026.
Very deeply obliged,
Thank
my lord.
Forward.
I'm obliged, my lord.
Thank you.
So Miller on 9th January.
No, start the matter. The applicant list will collapse. So start the matter. The part-heard matter, these are part-heard matters. Let us start.
Oh, Mr. Bagh should have argued. Why did he?
From the morning, he has argued at length. And he was under the impression that maintainability point will be, because the maintainability point arose during hearing, they addressed that. They were under the impression we'll reserve judgment on that and then. So I decided that here and then. And so therefore,
then
you
I
have no
can't-
such fetter. You did not have any such
No,
impression.
I don't have any such.
So please continue.
The issue here
Yes.
is just one of jurisdiction. What we've assailed is declaration of the petitioner as a willful defaulter by the identification committee and by the review committee. It has naturally been upheld by the review committee. I address your lordship on the merits on just one aspect of jurisdiction and the applicability of the master circular to me, whether the master circular applies or whether a person who's an executive director undisputedly can be declared as a willful defaulter. But for that, if I may just beseech your lordship to have a look at the supplementary affidavit once. Straight away indicate the point of jurisdiction here.
Yes. Which page?
Now, page 18, your lordship will please have a look at of the supplementary affidavit. File korichilo?
8, not 8. 8. Master circular.
Ananda.
18 years.
18. ভুল বললে বলো ঠিকটাকে ভুল করে দিও না
Yes.
18, whether if your lordship please has a look at page 25. Three, mechanism for identification of willful defaulters at page 25.
Yes.
May I?
Yes.
The mechanism referred to in para 2.5 above should generally include the following: the evidence of willful default on the part of the borrowing company and its promoter or whole-time director at the relevant time should be examined by a committee headed by, this is not relevant, just promoter director, whole-time director. B also, your lordship will please make a note. If the committee includes, naturally the second line also, show cause notice is to be issued to the concerned borrower and the promoter whole-time director. Even the last sentence of at page 25, an opportunity should be given to the borrower and the promoter stroke whole-time director for a personal hearing.
Lord D, your lordship will please have a look at. As regard a non-promoter or a non-whole-time director, it should be kept in mind that section 2 subsection 60 of the Companies Act defines an officer who is in default to mean only the following categories of directors: whole-time, where there is no key managerial personnel, such director or directors as specified by the board in this behalf, or who has or have been given his or their consent in writing to the board to such specification, or all the directors if no director is so specified. Every director in respect of a contravention of any of the provision of Companies Act who is aware of such contravention by virtue of the receipt by him of any proceedings of the board or participation in such proceedings, and who has not objected to the same, or where such contravention had taken place with his consent or connivance. Therefore, this bit, except in very rare cases, a non-whole-time director should not be considered as a willful defaulter unless it is conclusively established that 1. He was aware of the fact of willful default by the borrower by virtue of the proceedings recorded in so and so. 2. But this is important, by virtue of proceedings recorded in the minutes of meeting of the board or committee of the board, and has not recorded his objection. II, the willful default had taken place with his consent or connivance. The above exception will, however, not apply promoter even if not a whole-time director. This is something else,
Yes.
So this is how I want to address your lordship. This is a jurisdictional fact. To ascribe this liability of under the circular, the bank will have to come under DII and III to make a non-promoter or a non-whole-time director liable under. So an executive director can only be a willful defaulter if he satisfied II or III. That too in very rare cases. Therefore, except in very rare cases, a non-whole-time director should not be considered a willful defaulter unless it's conclusively established that, then again I and II.
So either they have to conclusively establish awareness from minutes and all, or it has to be a very rare case.
Well, rare case, that is also, as how I read it, and you will test it, that is also circumscribed by the conditions of II and III.
Probably not, Mr. Banerjee, because it says, therefore, except in very rare cases,
a non-whole-time
should not be considered as willful defaulter.
Yes, so that
the normal is non-whole-time director should not be considered as willful defaulter unless conclusively these are established, except in very rare cases.
Yes, so that
in
very rare case will come under II and III. As regards non-promoter, it should be kept in mind so and so who's in default, whole time is anyways there. No key managerial, such director or director.
It should be kept in mind as regards non-promoter, non-whole time.
Yes.
It should be kept in mind. Section 260 definition is just enumerated here.
Enumerated there.
It includes whole-time director also.
Whole-time director also.
So it starts with non-promoter, non-whole time, but this is just a statement of what is there in section 260. This is drawn as a reason for saying that
therefore,
circular says, yes. Therefore, from there the circular starts.
Except in very rare cases, a non-whole-time director should not be considered as a willful defaulter unless conclusively established that.
So therefore, a non-whole-time director normally should not be considered as a
unless I and II are satisfied.
Or I or II.
I or II
is satisfied.
Correct. So,
but in rare cases, it can be without these also.
No, DI to III is 260.
I to III, forget.
Yes.
That's just an enumeration of 260.
Yes. So even in rare cases, except in very rare cases, a non-whole-time director should not be considered as a willful defaulter unless it is conclusive.
So a non-hold time director should not be considered as willful defaulter unless these happen, except in rare cases.
Very well.
Except in rare cases, it can be done without these two also. But
yeah,
then high test of rare case has to be proved. So
very well, Milord. That's probably yes, Milord.
Take a minute and read it. Take except in rare cases separately, and then therefore a non-hold time director should not be considered as willful defaulter unless these two
a
happen.
non-hold time director, Milord, how I saw it was a non-hold time director is anyways covered under D. As regards non-promoter, non-hold time director, that's anyways covered in the whole initial part of D.
For all non-hold time directors.
All non-hold time directors, you have to is covered under D. So when you're bringing a non-hold time director in a rare case, you have to do one and II.
No. No.
But otherwise, possibly.
Definitely not.
But if I just read it as two separate sentences,
do that.
A non-hold time director should not be considered a willful defaulter unless it is conclusively established that. Then again, D, if I go back and read it, as regards a non-hold time director, it should be kept in mind, define an officer who's in default to mean the following.
D, whatever precedes therefore, is just a statement of their reasoning for
T, I to III.
From therefore starts the.
And anyways, even if I take this as it is, if I require to.
So then they have to show an exceptionally rare case.
That's right. So even if I take this as how I read it or your lordship is seeing it, without actually getting into that, let me first establish jurisdictionally what was the fact. Because it's a jurisdictional fact. Now, may I just start with this first? Please have a look at page 39 at supplementary page 8. No, supplementary page 8. Page 39.
Page 39.
No, page 8 of the supplementary.
Yes. Page 8.
Now here your lordship will see the show cause notice.
Yes.
Srivardhan Goenka, promoter, non-executive director, since resigned as on 7th October 2015.
Yes.
This your lordship has seen, my lord?
But then you are not a non-promoter.
No, I'll come to the promoter bit later. to show that I've actually never been a promoter.
That's right.
I'll just show that. But the notice, show cause notice, is issued to me identifying me as a promoter
and a
non-executive director, because I have, according to them, resigned on 7th of October 2015 of Duncan's Industries.
Right.
So now let me just, so with regard to whole time and director, this bit probably I'm out because I'm a non-executive director. So that part is out. Now with regard to promoter, Lord, please have a look at page 134 to 136 of the supplementary affidavit. Before that, your lordship can just have a look at page 90. The original subscribers to the company we have disclosed. We, the several persons whose names and addresses subscribed, are desirous of being formed into a company in pursuance of these articles, and we respectively agree to take the number of shares in the capital of the company set opposite to our respective name. Here, your lordship will not find the name of the petitioner. So the original subscribers, who are otherwise actually known as promoters, and this is a statutory document anyways, this my name does not figure. Now, one more, two sets of documents I'll just have to show. Page 134, if your lordship kindly has a look at. That will be supplementary volume 2.
And 130,
Milan.
134.
134.
134.
134. Your Lordship recalls the date that in the notice they say I've resigned in 2015.
Yes.
So as on 2013 also I was there in the company as a non-executive director.
Yes.
So this document is dated 2nd of April 2013. Target company Duncan's. This is under the takeover regulation, what has to be filed. Kindly turns over to 135. Name of the target company Duncan's at the top, first entry. 3B, please see. Names of promoters, members of the promoter group, and PAC with him as per annexure. Please turn over to 136 once more. There are 4 names, 3 companies, and one that of the other willful defaulter who has been declared as a willful defaulter, who is admittedly a promoter. Well, there is also nothing that the bank has come up with to show as to why they call me a promoter. I have now showcased that I'm actually the original subscribers also I was not there, and I was never a promoter. So when the bank is calling me a promoter to apply this circular to me, otherwise trying to get out of the rigors of 3, once they admit I'm a non-executive director, the bank should have produced something. There was nothing on record, nothing to show that the bank that call why I am a promoter. Statutory documents indicate I was not a promoter. Now, my lord, this point was taken by me. Your Lordship will please make a note, my lord, page 208 and page 212 of the writ petition.
ISG Traders Limited, Duncan.
Well, this I think
You don't
ISG, your Lordship will find the name at 136, one of the promoter companies.
So this is issued by the
Under
ISG.
takeover regulations, my lord, if
Under
I'm a promoter of a company,
Yes.
I have to disclose my shareholdings in that company and in what capacity I have.
Very well. But there is nothing from Duncan's to apart from page 90.
Page 90 and page 134 and 136. Duncan's promoter is only making the disclosure under the takeover regulations in respect of Duncan's.
Right. But ISG is one of them.
ISG is one of them. But I'm disclosing, my lord, who are the promoters of the target company.
Very well. Yes. What else?
Yes, my lord, this point was taken by us or the petitioner at page 208. Your Lordship will kindly see once of the writ petition. That will be volume 2. $208.
Yes.
Paragraph 5. This is part of my representation. I'm not troubling your Lordship with the merits of it. I understand the limits or as to how much I can argue here. As records will reveal, I was a non-executive director of Duncan's Industries till October 7, 2015. I had absolutely no connection with the management or affairs of the said company thereafter. Your Lordship will kindly please turn over to 212. This point of jurisdiction is also raised. Because it's a jurisdictional fact, I have to raise it before the authority first. So I'm showing that this point was taken. Paragraph 15 at 212. Clause 3D Master Circular expressly provides that non-executive, non-hold time directors should not be considered willful defaulters except in exceptionally rare circumstances. Apart from the fact that I was neither an executive nor a non-executive nor a hold time director at the relevant point, the purported show cause does not in any event mention any such exceptional rare circumstance to classify me as a willful defaulter. The purported show cause was thus completely
But you say you are neither an executive nor a non-executive. But you were non-executive.
I was a non-executive director.
So para 15.
Neither an executive or a non-executive or a non-whole time. There must be some, because there, my case is I was a non-executive director. That's the case I've come up with also.
You have not said, you have said that you are not a promoter also.
I'll just check that, I would have said that too.
Because that was the notice said that you are a promoter.
Yes, I'll just check that. But one more aspect I'll just indicate. There was another non-executive director. Yes, paragraph 13. Thank you. Page 211, paragraph 13.
Yeah.
Very good. Thank you.
Prospectus you have not annexed here. You
No,
refer to the
that is what we call a prospectus, the original subscribers of the company, which
Oh,
I
that was
showed at
on
page
page
90.
90.
Yes. Because that's the foundational document when the company is being incorporated. Paragraph 13, Your Lordship, will kindly make a note of no. The said purported show cause notice issued to me in the capacity of a promoter, a non-executive, is both factually incorrect and contrary to the provision of Master Circular. I was not a promoter of the said company, and as such my name does not figure as a promoter in the prospectus issued by the said company. I have accordingly also not been identified to be a promoter in the annual returns of the company. Neither I have received any remuneration from the said company and never exercised any control over the affairs of the said company. Admittedly, merely a non-executive member, that's why he denies director. Non-executive member on the board of the borrower company. It was apparent from the purported show cause that then it goes as to how I have resigned as a non-executive director of said company as bar fireback on 7th October 2015. Apropos me being a non-executive director, or it doesn't matter who I actually was, as long as I am not those three in 3A. Now, there was another gentleman called R.K. Bhargav, who was also issued a show cause notice. He was a non-executive director. The review committee, taking into account that he was a non-executive director, actually lets him go scot-free.
This is my annual governance.
And the annual returns, Milord, of Duncan's for 13-14, we have disclosed at page 118 of the writ petition. And 5, no? People that 105, Your Lordship will have a look at if Your Lordship has not gone all the way to 118. 105 is the annual report 2013-14. And 118, Lord, Your Lordship will find at, Lord, I must show 116 because this is something that the bank tries to cling on to, because here Your Lordship will find in the name of board of directors, my name appears. Petition number 2 is appearing at item number 2. It's the second name serially.
Page 100?
106. Then I'll take Your Lordship to 118. 106 is what is their clutch of straw of the writ petition.
Yes.
The second name is mine. What happens, earlier, there used to be a drop-down box. Every time you went and clicked on that box of a company, directors, irrespective of in what capacity, because that would be a part of the filing which you could access only through a particular password, but the drop-down box would show everybody's name. So here Your Lordship will find the annual report. My name is there. Of course, this is a document of the company itself, but my name is there in the second name. Now have considers page 118. It actual child.
And R.K. Bhargav is also there.
R.K. Bhargav is also there.
Which also justifies your point that he was admittedly a non-executive. His name was also here.
Non-executive director, Your Lordship has seen my name. And his name is also.
Because you see, he has been let scot-free on the ground that he's a non-executive.
Non-executive independent director.
So therefore,
that's my point.
It shows that.
That is why I'm showcasing 118.
Not in the audit committee.
And my lord, one more aspect, so that they don't hold me as an exceptional circumstance. Yes. My lord, taking a cue from what has just fallen from your lordship, A, kindly see the audit committee. R.K. Bhargav's name is there. My name, your lordship, will not find even in the audit committee. So it can't be that something was happening in the company, me being a non-executive director, actually, me being a 119. So the bank is going after me and let's say R.K. Bhargav for certain amount of knowledge that I've had with whose concurrence this whole thing has happened. This R.K. Bhargav was a member of the audit committee, naturally dealing with finances. But he was an independent, non-executive director. Although he had had 4 meetings and part of the audit committee.
You are also an independent non-executive?
I'm a non-executive director. But two separate things. One is the independent director.
So you are on different footings then?
No, he is also a non-executive director. His name is here, mine is not. Now, my lord, I've just indicated how I've taken the points. Lord, one more aspect, if I can just show.
Mr. Banerjee, please tell me the difference between a non-executive director and an independent director insofar as the role in the company is concerned.
Well, non-executive director would have, like from the annual return, your lordship has seen, he would have no role to play in the company, in preparation of accounts, in any managerial decision. In other words, he is not in charge of the affairs and functioning of the company.
So what is the difference between an independent and a non-independent?
Well, independent director probably draws a salary from the company and is on a slightly different footing in terms of what role he plays, which role is assigned to him by the board. But to a more specific reply, my lord, I would have to read up a little more and understand it. It's quite vague, as your lordship would have figured from my reply. I am not very exact difference between non-executive and independent, I wouldn't know. I know salary is a different, but what in terms of the managerial role?
Even I'm not a signatory of.
Therefore, independent director has less role in the company because he draws a salary and in a sense, he's a.
Which is why, I'm showing your lordship that Mr. Bhargav, the gentleman, he was a part of the audit committee also.
Yes.
So I am showing his role, but if he is allowed to go because of his nomenclature, then you are holding me just because I am a Goenka and my father is RP Goenka, GP Goenka.
246.
পরিষ্কার কপি না
246
দেখাচ্ছি এক্সাইটেড হয়ে যাচ্ছে কেন I'll just show to your lordship ভার্গবটা কোথায় গেল বলো with regard to Mr. Bhargav, what their RK Bhargav, what their finding was. Lord, before that, your lordship will just have a look at 246 will have 240
response to the submission of Sri Bhargav.
Yes, my lord, 249, if your lordship sees, it's slightly better copy. Admitted position, he was a non-executive independent director. And if I may just take a cue from the language that they have itself, they have only used. At the right-hand column, your lordship will find response to submission of Sri R. Bhargava at 249. Should I hand over a slightly better copy? The submissions of Mr. R.K. Bhargava with regards to his role as a non-executive independent director is acceptable. Hence, the name of Mr. R.K. Bhargava in so and so list of willful defaulters shall not be included.
Yes.
Now I'll just indicate how the review committee has dealt with mine. That is at page 246. It had a better copy down.
Yes.
The petitioner has not furnished any reply relating to the charges made against them in the show cause notice. This is response to mine. The replies do not address charges made regarding lower credit summation vis-a-vis the total revenue grant generated by the company 15, 16, 16, 17, 17, 18.
The review committee.
This is the review committee. Your Lordship will please once make a note of the period that is also here. 15, 16, 16, 17, 17, 18. Where admitted position from the show cause I've seen that in 15 I have retired even as a non-executive director. They somehow try to make me a promoter, but my date of resignation is an admitted fact. Bank has fairly, honestly, and reasonably followed the guidelines of RBI circular, and there is no oblique motive or arbitrariness in issuing the show cause notice as alleged. The show cause notice has been issued by following due procedure as enshrined in the guidelines of the RBI. In the context of issuing notice of willful defaulter, the notice issued or action initiated by the bank against the functionaries are not liable as alleged by the borrower guarantor. Hence, the show cause is lawful, valid, and shall be included. And what I had shown to your Lordship, those page numbers were actually my points taken in reply before the review committee regarding the jurisdictional fact. There has been no decision on that. So they have no other way to get out of it except by just relying on this reply is like my reply on executive director, independent director. As vague as it can be, yet seeming to give the impression that I know. So my first point is, first point is that because this willful defaulter classification attracts penal consequences, your Lordships have now laid down that it must be strictly construed. There has to be a strict construction given because in effect it's a penal clause or has penal consequences. When I raised this jurisdictional fact, as your Lordship had rightly pointed out, which is why I did not have to get into that whether this was a rare case or not, there is no basis on which even under 3 III they catch me.
No, this is the entire finding.
This is the finding regarding me.
Achha.
246 left-hand corner.
Yes, but those ingredients are missing.
There is no finding, nothing. And that is quoted. Now, when I have raised this issue that you could not have issued the circular on me, for them to, which is why I'm repeating this word, Miller, it's a jurisdictional fact. That fact will have to be first established for you to get that jurisdiction to proceed against me.
You have stated that you were a non-executive director and you had resigned already.
I had resigned.
You have not cited, not raised the jurisdiction point. The executive director itself, you say that.
They call me that.
But jurisdiction point has not been raised as such.
I have taken it, no?
In your show cause.
Yes, in my reply, Miller.
But yes, that portion at page 246, that is not even touched.
That's not even touched.
It's their version of your reply.
That's right, Miller. It's their version of my reply.
Very well.
In fact, paragraph 15 at 212, if your Lordship seen, I say that you can do it only in exceptionally rare circumstances. That they don't call out and put in the order. They only do a very, if I may use the word, a very perfunctory exercise of their discretion. and just say this is done in terms of the willful defaulter circular.
Yes.
Well, if your lordship bears with me for 2 minutes,
Yes.
that I'll just indicate with regard to the identification committee. Of course, that will not absolve the review committee from not deciding this.
You gave a representation before the identification committee also.
But I don't find that here.
So
I don't find that.
first time before the review committee, but yet review committee also had to consider.
Review committee had to come, but that's the whole point of having the review committee. One issue, my lord, that will arise with regard to the period that is there. I showed to your lordship at that particular page number, financial years. The even if that case is not really made out by the review committee, the account classification happened as an NPA on 29th of October 2016. This your lordship will find in the affidavit in reply at page 19. Well, page 19 of the affidavit in reply. Okay. All right. Page 19 of the affidavit in reply is a part of page 13, my lord, which was filed by the bank before the debt recovery tribunal as an evidence, which starts at page 15. Which
Page 13.
Page 15, your lordship, will please have a look at.
Yes.
Evidence on affidavit and NPA affidavit on behalf of the applicant being PW1. This is the bank's witness. Please turn over, my lord, to page 19. At paragraph
filed in what proceeding? What proceeding initiated by them?
Them.
Yes, bank versus.
Against the company, original application, 93 Act. Page 19, paragraph 24. The cash credit account, working capital term loan account, and FITL account having a so and so respectively have been declared as a non-performing asset on 29th of October 2016. This is affirmed as on from records that your lordship will find at page 21, paragraph 31. So the bank's own case is that October 2016 is when non-performing asset has been declared. And admitted position is that I have resigned in October 7, 2015. So with regard to the other so-called requirements of 3, that I had participated in this willful default activities.
No, but Mr.
It can proceed.
Yes, yes.
It can, which is why I was showing the period. The period there in that page 246.
Yes, that is relevant. 2015 onwards.
2015-16 financial year, that's April 2015 to March 2016. I resigned July 2015. October 2015. So if I marry this period with the date of NPA, I was actually not even there.
No, but you were there from
April to October. Those 6 months I was there. And the willful default.
Have done the mischief in during.
And then and I was not even a part of the audit committee. I was not on the board.
Yes.
There is nothing, and more importantly, Murad, at least the least I'm entitled to, even as a bad person, is reasons. Because that is really the heartbeat of any audit. Today, what am I not being able to assail before your lordship is the fact that there are no reasons. I'm having to conclude in 10 minutes or not trouble your lordship any further because there are no reasons anymore. There is no finding as to why this is a very rare case. Well, there's nothing else that I really need to trouble your lordship with at this stage. These are my respectful submissions.
Yes. Bank, you're the bank.
Yes, I'm for the
Right.
Lordship will. There are submissions. What I understand is that he says that the period is only post my resignation for which the show cause has been issued, which I will show from record is not a fact. Second, he is contended by showing some documents that he is not a promoter nor a whole-time director. The Lordship will kindly see the two stands taken by the petitioner himself before the bank. Firstly, may I just indicate, because the show cause notice also covers the period for 2013, is what may I first indicate from the supplementary affidavit. Lordship will kindly take up the supplementary affidavit. The show cause starts at page 8 and at page 10. Lordship will find that the unit defaulted in its minutes. I'll come to the second line just very briefly. Borrower company entered into marketing cum management contract with Nagri Farm Tea Company for Maribong Tea Estate on this and this. Further, borrower company entered into management contract agreement. This is for a subsequent period. Under the above agreements, borrower gave entitlement of entire realization from the sale of tea produced and manufactured from the said gardens to the assignees, and also the company to pay ₹1 per kg in respect of green leaves grown and or produced in the tea estate, this and this. So the period of 13 is involved in the show cause notice.
How?
Yes, the contract was entered with an agreement tea company.
Contract was entered.
Yes, and that contract was to give tea at ₹1.
That contract was a scam.
Yes, it was a scam. And Lordship has already passed one judgment with respect to Gauri Shankar Goenka. There are the facts. Now, since he has argued only on this point of jurisdiction, I'm just
Touching those.
Yes, touching those. So it is not a fact that the 2013 period was not involved. I mean, only the post resignation period was involved. Also, may I just answer this NPA classification thing also? They say that since they have relied on an affidavit of the bank and says that the classification of NPA was sometime in 2016. Lordship, we have clarified that in our affidavit in opposition at paragraph 11. It was actually, it had become a non-performing asset sometime on 16th of January 2012. So thereafter, it was.
Which page?
Yes, Lordship, it is our affidavit in opposition, page 9. Lordship will kindly take up the last paragraph. Facts remains that the account of the borrower company was classified as NPA on 16 January 2012 when the writ petitioner was a director of the borrower company. However, thereafter, account of borrower company was restructured. But upon default being committed in repayment of restructured credit facilities, the account once again classified as NPA and as
Since January 2019 is even before 2013.
Yes. So the NPA.
Your allegation is from 2013.
No,
NPA prior to that is irrelevant.
Lordship, firstly, my most humble or respectful submission is that willful defaulter proceeds on a very different aspect. Lordship's jurisdiction is not going to touch on the NPA classification, but since it is the case that
we are not touching on the NPA,
yes.
We are not even. We avoid NPA details.
Okay, but what I just only want to indicate is that
what you are saying is that if NPA was you are contradicting yourself.
No, I'm not.
Because if 16 January 2012 it was classified as NPA, the cause of action for classifying NPA must have been prior. And your fraudulent agreement is of 2013.
No, thereafter it was restructured, and what is the RBI norm is that I'm carrying that circular with myself. Lordship, once an account is restructured, then in a case of a subsequent default, the date of NPA will go back to the original date of classification of NPA. That is all I am on. If I have not been
You
able
don't
to-
get my point.
Yes.
Probably I could not clarify. If it goes back to the original date,
Yes.
then the original date is January 16, 2012, when that agreement was not even entered into.
No.
So therefore, how can that NPA be a basis of?
NPA is not a basis of the willful defaulter, is what my submission is. Since my learned senior friend has relied on the date of classification of NPA, I just wanted to reply to that, that the NPA is firstly not a pertinent factor. Willful defaulter guideline is completely on the master circular itself, and it has to be confined to that. But in respect of this account, it was initially an NPA, thereafter restructured. Thereafter, in case of a subsequent default, as per RBI guidelines, the NPA goes back to the date of original classification. Is that only briefly responding to that aspect? Now, Lordship will kindly take up the writ petition at page 59. And Lordship, before that, Lordship will kindly take up volume 1 of the writ petition at page 40. Very similar looking documents. Yes. All I intend to show
Yes.
is that
Page 40 of writ petition.
page 40, it is.
Yes.
It reply starts at paragraph 49 directly. This is their reply, the show cause.
Whose?
Lordship will kindly see at page 40.
Yes, Srivardhan is also.
Gauri Shankar, Srivardhan.
Srivardhan is there.
Yes, and one more company.
Yes.
40. Yes. Now, at page 49, Lordship will kindly take paragraph 35.
Yes, 35.
49, sorry. Yes.
Page 49.
Yes.
Para 35.
Lordship will kindly sees there's submission interim resolution
This
profession.
was the reply to the willful
Yes.
defaulter committee.
Yes, to the show cause, I believe. Yes, this is a reply to the show cause. Lordship, it is dated 20th of March 2021. Show cause was dated 26 to 2021. Yes, this is the reply.
Original show cause.
Original show, the show cause.
Yes.
Page 49. Says, interim resolution professional accordingly took charge of company and on and from 5th March 2020, and Mr. G.P. Goenka and Srivardhan Goenka, who were members of the board of the said company, stood suspended. In fact, Lordship will kindly see that our clients also in the first page says suspended director. I'm just trying to show that what is the conduct of the petitioner before the respective committees being. Goenka, who were members of the board, stood suspended. Mr. G.P. Goenka and Srivardhan Goenka, both our clients, they ceased to have any control over the affairs of the company from 5th March 2020 onwards, and the bank accounts of the said company were under the control of and operated by the the said interim resolution professional. As such, Mr. G.P. Goenka and Srivardhan Goenka, both our clients, has no means to settle the dues of SBI. Now, Lordship will thereafter.
So they say they cease to have cease to have control from 5th of March 2020, which is subsequent.
Lordship will thereafter take up paragraph 44 of this reply. So what was before the committee as on that, for the purpose of consideration, Lordship will kindly take up the last few paragraphs of lines of paragraph 44. Lordship can find Mr. G.P. Goenka and Mr. Srivardhan Goenka. Lordship has found that. In the capacity of promoter directors of the said company.
No, sorry, this is which paragraph?
Paragraph 44.
Page 44.
Paragraph 44, page 52. The same show cause reply. Mr. G.P. Goenka or Mr. Srivardhan Goenka, in the capacity of promoter directors of the said company being our clients above named, can survive the show cause notices under reply issued under commencement of CIRP against the said company and threatening to declare GP Goenka or Mr. Srivardhan Goenka willful defaulters are contrary to law and to the established precedent. Now, Lordship will thereafter kindly take up paragraph 47.
Yes, 47.
Page 52, paragraph 44, last line.
47.
47, paragraph 47. Now, it is stated in this regard that said bank account of ICICI Darjeeling Bank was maintained for operational convenience of the gardens managed by the company. Total transaction through the account, this accounting period was only a paltry sum, and to the knowledge of Mr. GP Goenka and Srivardhan Goenka, being our clients above named, the said account has been seized by the Chief Labour Commissioner on account of an outstanding Provident Fund dues of the workers at the said company. So it is their averment that he had knowledge of accounting, which also I will show from their documents, that he was completely having knowledge of accounting. Now, again, Lordship, page 59. Lordship will take up that this is also their response, a letter, not a reply to the show cause. That was the reply to the show cause. So show cause is replied by the petitioner as being one of the promoter directors of the company. And he also claims to have knowledge for subsequent periods. Lordship will thereafter take up page 59. My client, Srivardhan Goenka, promoter, non-executive director. Lordship is found, my client, page 59.
Yes, yes.
So he claims himself to be a promoter. It is only subsequently that this something strikes and he comes up with this the rigors or the escape routes from this master circular, and subsequently he comes up with that. Also, what I Lordship, also from the pages relied upon, that is page 90, Lordship, 90 of the supplementary affidavit, which was just no, that was the 90 was the supplementary affidavit or the respective, yeah. Of the 90, although I have just checked up very briefly, but I don't even find the name of Srivardhan Goenka, who was just now said to be the promoter of the company. Lordship, I have just checked up now. Is Srivardhan Goenka's name appearing here? No, he's not.
That is his point.
No, sorry. Gauri Prasad Goenka.
His name is
Is his name there? I just checked up. I could not find. So that is why I am indicating that I can find name of Arun Wadhwa, Hemant Kumar Sharma, S. Tandon, M.R. Rajaram, M. Krishnan, A.K. Bakchi, and Vikas Agarwal. These are the names I can at least locate, but admittedly in that other letter which was shown to your lordship, Mr. GP Goenka has been said to be the promoter of the company. So this is not the document from where it can be ascertained that he is not the promoter of the company, where he has given so many representations to the bank contending or admitting that he's been a promoter of the company. So,
but this is the prospectus. He says that, and it also says we want to form a company and all.
Yes, but lordship will finally see the total 70, and then the name of GP Goenka is not appearing. Now, if I place the other letter,
yes,
which was just placed before your lordship, that is at page 136, that shows the name of Mr.
Yes. 136.
136, I think, was
supplementary
of the whichever document. 36. The letter of the
page 52.
No.
And 59.
No, 136 are shown by them, which is 100, starts at 134.
Okay.
The ISG Traders Limited, that undertaking document.
Oh, that's the other one.
Yes, Srivardhan Goenka's name appears as the promoter. So, the 136 you just showed.
136, yes.
Yes.
No, he's not shown.
No, Gauri Prasad Goenka. That is what I'm saying. But Gauri Prasad Goenka's name appearing at page, he says that Gauri Prasad Goenka is a promoter. And kindly looks into page 90, there is the prospectus list where the names of all promoters are appearing. Now, I don't find the name of GP Goenka appearing there as well. So this is possibly not a document which can be relied upon to ascertain this fact also together today. There I cannot find the name of Mr. GP Goenka at least. If this is the only page that has been relied upon by them, because this I just scrolled through very shortly. So now, Lordship will thereafter take their.
So he has relied on R.K. Bhargava and you are relying on GP Goenka.
We'll come to R.K. Bhargava because I'll answer to Lordship's question of what is the difference between a non-whole time director and an independent director. Independent director is a person who will not have any connection with the company or its other promoters at all. He is out of the ecosystem. He is appointed independently. A non-whole time director is a person who will be within the ecosystem. So he is somebody who is independent director, is somebody who is completely neutral. He is a professional having certain qualifications appointed to act independently for the company, which a non-whole time director is not. So there is a complete difference.
And his salary also as Mr.
No, salary, he has drawn salary. I will show that.
He's also salaried.
Yeah. Yes, this petitioner is also salaried.
Petitioner.
Petitioner is also drawn salary. That is
Anyway.
at page 122. 122, the petitioner's salary is shown. Lordship will kindly take it.
Not that. That would go against him anyway. If he's
so
professional, very right.
He's not drawn. He's drawn the board salary at page 122. Lordship will kindly sees that the difference in the salaries at page 122, he has drawn salary as at 50,000. He just did not draw salary as being a member of the audit committee or the nomination remuneration or the stakeholders relationship committee. But
page 122.
122 of the supplementary affidavit. He did draw a salary of 50,000. So this argument, I don't know why this is made, but salary lordship is found page 122.
122
of the supplementary affidavit.
Yes.
Duncan's Industries Limited, details of remuneration paid to directors for the year ended September 30, 2014. Supplementary affidavit, lordship is.
This is a supplementary affidavit.
Supplementary.
Sorry, repetition. It's very similar looking documents. I'm myself getting confused.
I can't make them look differently.
No, the volume is also very similar, both.
Yes.
Lordship is found 122. There is a remuneration drawn by Srivardhan Goenka to the tune of 50,000 rupees. Now, there was one more submission made that he does not take part in the accounting of the company. So, Lordship will kindly take up the balance sheet from page 136 onwards. This is the balance sheet.
136 of what?
Of the writ petition. Same document.
Yes.
Lordship, the balance sheet bears the sign of Srivardhan Goenka, name of Srivardhan Goenka. Lordship has found the right-hand corner. Above directors, there is the executive chairman, and then there are directors, Srivardhan Goenka at the top.
Unbelievable.
Lordship will thereafter take page 166. That should be in volume 2 of the writ petition. Lordship will
Sorry, this is page.
This is the balance sheet. As on 30th.
Which page?
No, subsequently I'm coming to page 166 to
160.
show
Yes.
his active involvement. I will also show from other documents with this accounting part. Lordship has found that consolidated statement of profit and loss for the year 30th September 2014. Lordship will see as director there is only a single person who has signed. That is Srivardhan Goenka. 166. The executive chairman is GP Goenka. Director signature is only of Mr. Srivardhan Goenka. So there can be no second opinion of the fact that he was actively involved, which will also be established from. Lordship will kindly take up 109. Let me check which 109. Lordship, this is 109 of the writ petition again coming back. The document, in fact, they relied on starts from page 106. Now, they say that I have he's not an director, full-time director, which is also showing non-executive director, not non-full-time director. Against his name, that is at page 118 will be convenient. That is a tabular sheet. There is a table, sorry. There's a table there, page 118 of the same document. Lordship has found that the executive,
non-executive director.
Non-executive director. And Lordship kindly sees that how.
So what? As opposed to independent director, you were saying?
No, as opposed to independent director,
non-executive director he's admitting.
Yes, non-executive director.
He says that he was a.
So that is fine. I'm seeing that he's a non-executive director, but there is nothing on record to show that he was not a promoter. Number one. Second is that even what I'm trying to overcome is that therefore from the circular that he was actively involved and had knowledge is what I'm trying to establish here. If that he, even if my submission is possibly
No, non-executive director, he was admittedly a non-executive.
Yes, that is, I am not.
You need not show any document for that.
Really showing that 5 out of 5 meetings are attended by him. He's the only person, and Mr. S.K. Kindra, these are the only persons who were attending the 5 out of 5 meetings, including the AGM. So whether the AGM was attended, Lordship will find that there is a third column after 5 out of 5 meetings attended by him, and that there is another column whether the AGM was attended by him as held on 30th December 2013. So that also says yes. So what I say is
active involvement.
Yes. This is what I am on, that even if I consider him to be a non-executive, non-promoter, then also his active involvement can be shown from documents they have relied or disclosed before your Lordship today. Lordship, I have shown that he was drawing remuneration as well. Now, Lordship will kindly take page 179 again. That is volume 2.
Of the writ petition?
Of the writ petition.
179. Yes, that.
Because Lordship has seen that this consolidated statement has been signed by Srivardhan Goenka.
Yes.
Yes. And in that, Lordship will kindly find that page 179, that there are doubtful other advances considered doubtful. There are doubtful advances. 179. Lordship has found that it's a third.
Doubtful, yes.
Yes. Considered doubtful. Lordship will kindly see that what is the nature of the doubtful advances made by the company, and this is under his signature.
No, doubtful
Yes.
per se does not mean that it is fraudulent or
No, Lordship,
for the
willful,
purpose
not
of
fraudulent.
willful
Yes.
defaulter also.
Yes. So the company is all I'm trying to establish.
Advance is
that-
considered doubtful, or that is a head under which the it's like a, I mean,
No, Lordship, yes, I understand what is falling from your Lordship, that it can be include many things maybe, but what all I am
whatever there is a doubt regarding, I mean, then it like bad dates, I mean, whatever.
okay, I'll not press on that.
No, but we are recording your submission on that because
On all that I'm trying to show from records is, number one, he has all along stated in the show cause, he has stated that he is a promoter, director. Then he has his active involvement in the company can be shown from these documents. He has been actively participating in all the proceedings, all the meetings conducted by the company. He was present in the AGM, and this balance sheet is under his signature. So he cannot be said to be a person who does not have any knowledge of the accounting of the company, or that he has not acted willfully. And with respect to the reasoning, Lordship, that Lordship, I beg to rely on a judgment. Lordship has, I somehow have missed that, but Lordship is aware of the proposition that these are administrative orders. So even if that judgment has not considered expressly, that objection, which I have to be very candid before your Lordship, was before them, because I have checked up that date, although it was not a reply to the show cause, but it was there on the date when it was being considered.
that was a reply. That was a representation to the review committee. At least the review committee ought to have
No,
considered.
that is not a, that is not yes, to the identification committee.
Review committee.
Okay, that is
Identification committee have showed us
Yes,
that they
yes.
described
So
it.
Lordship, they have described themselves as a promoter. No document, no proper document has been brought before the bank today for consideration of whether he was not a promoter, which is contrary to what he has stated all along, and also most respectful Lordship, will give me a minute. They did not represent themselves in the hearing. Yeah, because they did not represent. So no, they were called for a hearing and they did not represent. Somehow I did not check that up finally. And
Mr. Banerjee does not know that.
yes, no, but they were not present for the.
Let us come back to that 3D ones.
Yes.
Because that was the plinth of, he started with that, Mr. Banerjee.
Yes, yes.
Supplementary application.
Page 26, supplementary.
Yes.
Lordship, and what has fallen from your Lordship, what I also beg to state is that there was otherwise no purpose to quote this entire section 2 subsection 60 of the Companies Act if this did not have a meaning to the subsequent lines.
No, that
Yes.
meaning is lost. Why I tell you, please read that. If it deals with, it starts with as regards a non-promoter. The whole time director has been dealt with previously in clause A.
Yes.
Clause A says evidence of willful default on the part of borrowing company and such whole time director should be examined. Now, D deals with specifically by excluding whole time directors,
Yes.
non-promoter and non-whole time director. But at the same time, clause I of 260 is whole time director. So why mention that if it's not only for guidance or for drawing inspiration?
Yes.
This cannot be a guiding factor.
No,
Which I told Mr. Banerjee also.
Yes. So the exception from therefore.
No, but you say this is confusing in a sense. It could have been confusing unless you read it as just a guiding principle.
Yes.
As regards a non-promoter, non-whole time director, it should be kept in mind that section 2 within bracket 60 defines an officer in default. One is whole time director. So this per se could not be a incorporated in this this definition of.
Yes.
And you start your thing, this master RBI thing starts with therefore. That is the definition. Therefore, except in very rare cases, a non-whole time director should not be considered. So by default, non-hold time director, he's a non-hold time director, should not be considered as willful defaulter unless you conclusively establish that he was aware of the fact of willful default by virtue of any proceedings recorded in the minutes of meeting of the board or a committee of the board and has not recorded his objection. Where is this finding? You say merely that he had attended and his active involvement is written galore over the records.
Yes.
Very well. He was actively involved in the accounts of the functioning of the company. But where is a single line of recording even or anything to show that he attended a meeting by virtue of which he was aware of the willful default? So he has to be aware of the willful default from a meeting where he did not object. Nothing of this sort in your reasonings.
Financial documents, the documents which have been disclosed.
Neither from the financial documents, in the reasoning there is precious nothing. And
Reasoning,
who is or is the willful default had taken place with his consent or connivance. That is what is to be seen.
Yes.
Not that you rope in whoever is there.
No.
Active connivance, that is particularly that holds true for non-hold time directors. Hold time directors, the default provision is reverse.
Now, Lordship, there is one more thing.
Yes, burden is shifted rather.
Then the next line will be pertinent in this case, which says the above exception will, however, not apply to a promoter director, even if not a whole-time director. Now, this is an area which is grey. Today, most respectfully, Lordship, this is not been cleared before the bank.
This is not been?
And this is not clear. Till date, it is not clear.
If it is not clear, you could not castigate him.
Lordship, according to his representations, he is.
On unclear things you can do.
Yes.
You have to use it. It has penal consequences, as rightly pointed out by Mr. Madam.
I completely bow down to that. I am aware.
Marked as a willful defaulter.
But this exception, Lordship, will not be to a non-hold time director who has been a promoter. So now he says I'm a promoter. Subsequently, he changes his
advocate's letter says he's a promoter.
Yes.
But the promoters, the prospectus shows he's not a promoter. Documentary evidence should prevail.
What document? That document, Lordship, if that is the document, because Lordship, the best evidence is with them.
No, the difficulty we are not deciding that. We have to see whether you decided that. Not a single line is attributed in your reasoning.
I have seen that.
That is the difficulty. Your reasoning is very poor.
Very poor.
And we have been always telling learned counsel whenever they appear, I mean, either for the banks or in case of those LOCs, Mr. Banerjee knows, we are repeatedly saying, you comply with the law, why should we interfere? We had no fun in interfering in these things. If someone is a willful defaulter, in your perception, we cannot interfere much. But you have to comply with the law, your own RBI guidelines.
The order is completely silent on that aspect.
Completely silent.
I have checked up. Yes.
And he took the point specifically before the review committee. Now, after Justice Nariman's judgment and long line of judgments after that, it's clear that review committee has to consider it.
Yes, that is there.
Independently. That is rejoinder. Nothing
Lordship,
is considered.
Lordship, most respectfully,
if I was the review committee, I might have been convinced. But difficulties I am not.
I understand. I completely understand what is fallen from your Lordship. I'm aware that the order in the language it is couched, it does not record these facts or whatever the submissions even I have made before your Lordship is what is.
No, but which exception? Let us come back to this second clause.
Yes.
The above exception. Exception, the word except is used only once.
Yes.
So whether the entire thing is taken to be the exception or this except in very rare cases.
No, I think the except in very rare cases.
If it applies to that will not apply, then what remains?
No, if he is a promoter director, then even if he is a non-hold time director, he will not get the benefit of these except in rare cases.
All right.
So that is what my reading of this portion is. Now the order has been drafted and it does not reflect this exception being carved out, that I'm aware, Lordship. I will have to be candid before your Lordship. But from records, it can be.
Moment to say that Mr. Banerjee stands up.
No, because from records also, I must, there's a different way that we address your Lordship. I must satisfy your Lordship's conscience also. I understand on technicalities, no reason I
What
go.
about the others?
No.
No, but
if she has concluded, Milord.
Yes, otherwise, there is nothing much. I do not have anything more to show from this record. And Lordship, only submission is that the reasoning may be flawed. But today, before your Lordship, there is a record from which the ultimate conclusion may perhaps not be wrong. So that is.
But a lot of emphasis has been placed on two letters to show I have admitted that I am a promoter of the company. First, page 52, paragraph 44 has been relied on. I'll just show that, and another letter, because the draftsman of the letter is to my right, when she was sitting cringing there for her admission.
Yes, I was going to ask. I restrained myself actually. I was going to ask whether they are the same. The same advocate on record is still there.
She was
That
sitting.
I was just going to ask, but then I restrained myself precisely due to that reason. I thought that it
if
would be
for
the same.
her letter someone's going to become a promoter and become a willful defaulter. Then I read it again, and maybe she is not at fault here, or as an admission, let's just let her keep her out of it. Page 52, paragraph 44, please have a look at. What was highlighted was, but please have a look at the sentence. It is further settled law.
Page 52.
Page 52, paragraph 44.
Yes, it is further settled law.
Yes. That upon conclusion of the corporate CIRP, either with the passing of a resolution plan or the liquidation of the said company, the said company shall stand absolved of any willful default, and in the circumstances, please mark this, Manoj, no allegation of willful default against either X and the petitioner.
Refers to the allegation.
That's right. Also, my lord, page 59. I assured her I'll show your lordship all this because she would have been in page 59. I'm sorry, my lord, only my client Srivardhan Goenka that was shown. Please have a look at the first sentence. This is a reference to your letter dated issued to my client alleging him to be a promoter of. This is from the show cause notice as to how they have identified her client.
One matter, Mr. Banerjee, the trial court had observed the allegation was by the plaintiff against the defendant was that he's allegedly the son of such and such. That was repeated when he challenged that in appeal. He also wrote his own father's name as allegedly the son of. You are the plaintiff. You get a decree against me by stating, adding me as defendant, saying that so and so allegedly the son of such and such. That was the premise. If I am not the son, the consequence is otherwise. What a decree. I am challenging that in appeal. I say, I allegedly the son of such and such. I distinctly remember I was the advocate on the other side, luckily.
But this was when you.
I showed that, yes. He says that he's allegedly the son, then case anyway. So it's like that probably.
Here the letter has.
Here in the cost title, she has said promoter. He has said
because
promoter.
My client, your lordship is seeing there's a reply that's going. It's how I have been exacting a set out. And then this clarified, alleging him to be the promoter of Duncan.
Page 52 is better than 59.
52 is better than 59 also explain.
59 you say that, yes.
59 I explain it. That, and 52 also I say the allegation stating. One more thing, because
52 is better for you. That is what I'm saying.
52 is better for me. 59 also.
59 within bracket you say promoter. The caption, my client.
That is how the show cause notice classifies me. Exactly this.
You are not saying that. That's exactly what I'm saying.
Right under
like that case where in the cause title, the logic of the other side's advocate was that was how it was set out in the decree.
Just after sir. Just see after sir.
No, that he has stated.
Alleging him to be the promoter. So I have
stated alleging him to be the promoter. But I am showing you before sir.
Oh, my client is alleging to be.
Before sir. Post and pre sir is different.
One more aspect.
That's why probably sir is under such scrutiny throughout the country. Maybe one of the reasons. Anyway, but yes. So
one more
alleged to be.
Alleged to be. One more aspect, the salary aspect was brought out. I don't think it was particularly relevant, but I'll still show it.
Salary you are drawing 50,000. We have no qualms with that.
That's just specifically recorded at page 120. It's for the sitting of a non-executive director.
Yes.
Because a non-executive director, otherwise he can't be a part of these. I'll just show that.
I mentioned salary, Mr. Banerjee, that we are talking probably at cross purposes. I'm telling you why. Because
That I'm non-executive as an
when
arbitral.
when Ms. Lahiri was arguing, I told her that independent director was a salaried person, trying to mean that he was not. I mean, he's a professional. I was supporting her in a sense. She was saying independent director is a professional.
Hmm. Now, she
Engaged
has also shown
independently.
that I have also taken salary.
Yes.
So I should not dispel it.
No.
Alleging that father,
No,
alleging son.
that is what I'm saying.
Very good. One other aspect, page 136 and all those signatures were shown to show that there were no signatures. My names were appearing in those accounts or balance sheets that were filed. Apart from the fact that this has not been considered at all,
You are everywhere.
those names
You
were
are
there.
signing everything.
I'm not signing, that is what I wanted to show.
You are shown
These
as a
are
director.
in every balance sheet of a company forms part of the annual report.
Yes.
An annual report, every balance sheet has to declare who are members of the board, who are your directors in every, which is why I had shown 118
Every page has to be signed of the balance sheet.
by not these persons.
Where do you get it?
118, please see. Well, all these documents, balance sheets that were shown are part of these annual returns, annual reports. 118 is the main, yes. There my name is as a non-executive director. So wherever else I'm appearing as a part of that report, I'm actually a non-executive director.
The argument of the bank was that you are appearing, you are signing balance sheets, profit and loss accounts. Several pages were.
But if I look at
Giving
page
you the pages.
136, if I look at 136,
136, 166.
my name signature is not there anymore.
136.
Signature goes from the chartered accountant. These are companies which are with their audit.
Oh yes.
These are all signatures of chartered accountant. Left, your lordship will sign. For how much we've troubled your lordship, I'll keep the name of the chartered accountant silent. This name has been troubling your lordship of late quite a bit.
No.
But right hand corner.
No, if that succeeds, then the signature would also go.
This is Chartered Accountancy Council, all of that, yes.
Yes.
That is also.
This is challenge there.
This is that, yes.
This is challenge
This
there.
is challenge.
See, if he loses there, if they lose there, then this
his
also goes, they'll
authority
again
goes-
issue a show cause notice. So this balance sheet was fraudulent.
So
Anyhow.
here, my lord, all the names of the officers, COO, CFO, secretary, managing director, it's a part of an annual report of a company. This has nothing to do with my involvement.
Apparently, yes, because
All these documents are by law.
yes, there is.
All these documents will
Yes,
find.
like these do not. We don't find anything. Rather, for the chartered accountants, for means someone signs for.
Lordship, most respectfully, then in that event, all the names of the directors would have been there. It is only.
Oh, your point was that only his name was shown as.
Yes, he is shown as the director.
No, that too immediately under that
Hardcover was
was also there.
But in the other page, that is page
That one,
160.
only one name is there.
But there
That
in
is
the
also part of
166 is the
118.
consolidated statement.
That's a part. This can't be the bank can't go about clutching straws in the dark.
No, it
And
is-
and this must flow from something. I could have actually explained it if they had found.
No, Lordship will.
There's nothing to show that this is an exceptionally rare case. Some finding.
That remains. That remains.
But here I'm doing this just to actually satisfy the conscience of the court. That I'm otherwise not a thief who's getting out because there's no reason. I'm really trying to labor on that here. I was not there in this company at all. Just because my father is also going and I'm his son, I don't become a willful defaulter.
That submission is possibly not right, but I know that there are not.
What is interesting is whether
reasons,
you're a Goenka or a
but,
Or the balance.
Bhattacharya.
this submission is possibly not right.
But there is
because there
otherwise, there is absolutely no basis.
No, you're shown as a direct at page 166. 166
is also a part of the annual returns that are filed, of which
Yes.
118 is the precursor.
So where is the signature of at the end or the beginning?
There is no signature. No?
Somebody must have signed before filing it.
The accountant will file with the approval of the board, like any other auditor files for a company and annual
Actually,
return.
that I mean,
Lordship,
the directors themselves do they sign the?
there are parts where the
We don't know who signed. There is no signature appearing from this annexure.
Well, with
Nor was
that,
anything referred to in your.
these are documents today which are disclosed before your lordship by them today.
No, he's saying he's an executive director,
They also do.
but it's nobody's case that he was the only director on that date.
That's
So just because he was shown as the only director does not mean he was only in control.
what
That's a circular
what
logic.
I was trying to convince your lordship was, although I know the limitations in this record, but
Only his name.
is that he has been actively participating in all the affairs of the company.
Look,
he has been actively
That if I'm on reply and I
signing-
have to deal with that, that is
He
not.
was an executive director in 2015.
That.
yes.
Your
so,
lordship,
so
I have to
had
be
to
part
No,
of
just
the.
because he's lady.
My involvement doesn't make me a
Let's
willful
be
defaulter.
clear on this. Very clear on this. Willful defaulter is a different ball game altogether, if I may use
Yes,
the expression.
yes.
All the directors may be actively participating in the affairs of a company. Executive directors can at the same time do that. That does not mean unless you satisfy the willful defaulter circular,
Involvement
you
in
cannot
relation to the
embroil him
willful
in
defaulter.
some declaration of willful defaulter. You have to satisfy those criteria.
Yes, that is there.
Whoever is engaged with in a company as director,
It is
executive
not a
director,
simplicity engagement is all I was indicating from the conduct and from the
What
showing
conduct?
that
he's being shown as a
he was
director.
aware of the no, not that. He was aware of the financials of the company. He had signed in this.
We don't find that he has signed.
The
We don't find that he has signed in this document. He's right on this.
Now, possibly these are all electronic.
Also, my lord, that's why
Therefore, his involvement cannot be, clinched on the basis of that he signed this document.
it has to be in
He has
relation
a point,
to
Mr.
the
Banerjee has a
willful
point in saying
defaulter.
that maybe the audited accounts, chartered accountants, they file. The filing is done by the authorized persons of the company.
Yes,
Directors then do not themselves sign the. This is not our income tax returns that we
Sign
the balance.
try and
possibly, I will. I don't know. I'm not right. Not the right person.
Retrospectively, even if you find out something, we
Even
cannot,
no, that I understand.
nothing is restricted in the.
This time.
look, this is what we had to trouble your lordship with.
Hearing is concluded. The matter is up for that.
Very good.
Yeah, are you enjoying a stay order?
Yes.
Yes, there is.
So then this may be kept for appeal.
Yes, yes.
Because there are already so many accumulated matters. Yes.
Sorry for troubling your lordship.
No question of trouble. I troubled myself actually. Called it up. Yes. যেখানে পাঠাবার পাঠিয়ে দাও রুল ইস্যু হয়েছিল যেগুলো আগে রাখো
My lord, I'm the petitioner. The rule have been issued, my lord. Copy have been served. Everything have been served, but today she is not present here.
No, this is appellate side. In connection with the present contempt application, a rule was issued on November 14, 2025. Full stop. It is apparent from the office report dated December 18, 2025 that the contempt rule was sent by special messenger Vide memo number 772-MD dated December 16, 2025 for effecting service upon the contemner. Full stop. The same was also received by the office of the concerned contemner on December 18, 2025. Full stop. However, despite the service of the rule, the contemner does not appear personally, comma, nor is represented by counsel. Full stop. Next para. Accordingly, a warrant of arrest be issued immediately in order to ensure the personal presence of the contemner before the court on January
My lord, may I?
9.
19, my lord, 19. Because I'll be out of station, my lord, till 16. I have also circuit bench matter also there. So kindly fixed it 19, my lord.
January 23, 2026 at 3:30 p.m.
Much obliged. Much obliged.
Huh? Oh, 23rd January, na? Then it will be January 30, 2026. Thank
30.
you. আর এটাতে warrant of arrest এটা তাহলে অফিসকে জানিয়ে দেবেন না ছেড়ে কমিউনিকেট করে yes next
Item number 12.
yeah oh,
Your Lordship, on the last occasion, was
Yes.
pleased to direct us to find out whether there is any method of computing the loss.
yes
Your Lordship may recollect, my lord, that
Yes,
loss. What we have done in the meantime, my lord, we have gathered some material, not my lord, case-specific material, but general material. My lord, if your Lordship kindly takes this, may hand up a copy of this particular instruction which I have received from a client.
yes
Madam, may I just take your Lordship through the instruction? Madam, this is a case of yield loss. Madam, there are different kind of losses. Madam, for example, madam, one is yield loss, another is post-harvest loss, localized loss. Madam, this is the case.
what is covered by this insurance
Madam, everything is covered by this insurance. But there are different kind of losses which may, but the yardsticks would be different, obviously. We could gather from the official website of the government of West Bengal, madam, what was the percentage of yield loss, not other losses. There may be other, it may be a case of post-harvest loss, which we do not know as of now, because there is no policy of insurance as of now. Now, my lord, kindly take this, my lord, if your Lordship kindly takes, as per BSB guidelines, but that is this Bima Yojana guidelines, shortfall in yield is calculated as per the following formula, which your Lordship will find in the guidelines itself. Threshold yield, my lord, that is the normal yield. Under normal circumstances, this should have been the yield minus the actual yield. Well, kindly do not mind that there is a typo here. Actual yield divided by threshold yield into sum assured. Well, this is page 11 of the BSB guidelines. Assessment of yield loss is based on insurance unit basis. Insurance units for potato crop was Gram Panchayat. For that was the standard. As we do not have any farmer data in this case, we are sending that is our instruction to us, the loss percentage data of each Gram Panchayat under Kotulpur block. This is Kotulpur block. So what we have found out, the Kotulpur, there are 8 Gram Panchayats I find. For each Gram Panchayat, the percentage of loss is different. She will find state government actual yield, but that's the state government data. That is 6627. Then state government, my lord, this is threshold yield. That is 25166.12. Then we apply the formula, obviously. Then we arrive at the percentage of loss. So we have done that. This exercise we have carried out taking the data from the state government's official website. But I am not in a position to make this statement before Lordship. What kind of loss they suffered, whether it's a case of yield loss, whether it's case of post-harvest loss or other two losses. Sowing loss, localized loss. But this is all, my lord, I tried to get all the possible data.
done your level best.
We could, that is all, we could do, my lord, under these circumstances.
So what can be the modality?
My lord, the modality, my lord, may I
You will have
suggest?
to satisfy what
My lord, it could have been done, my lord, I subject to correction
relevant
by all
period
my
it could have
by
been.
all my learned friends. My lord, it should have been done, my lord, at the very onset of the
Absolutely.
Losses.
That has not been done.
That has
That's
not
why
been
you are all of us are.
that is the difficult.
My lord, one thing is also there, my lord, subject to what my learned senior friend
Yes.
says. My lord, the farmers, Mala, they are supposed to intimate this loss within 48
That is
hours.
what I am saying. That is what I am saying. That is what I'm
The entire readment, there is not a single communication with the bank, my lord. In the meantime, I have tried to find out the first communication is of the year 2023
They would not be entitled at the threshold.
at the threshold.
This is the difficulty, my lord. We tried, my lord, whatever data we could gather. This is a peculiar case, peculiar facts and circumstances.
The communication 2021, not 23, my lord.
No, no,
Communication.
absolutely.
No. Where is that provision on the last
My lord will kindly takes page number 31, my lord, of the recalling application.
Kindly take my recalling
Yes,
application.
page number 31.
Immediate intimation, right? You please come to that. Page 31.
Internal page 15.
15.
Malab,
I have it marked.
What is our understanding? Malab, I will stand corrected. Malab, this is seriously not Malab, I cannot make that comment with some kind of authority. Malab, we understand this to be a post-harvest loss.
Yes.
This is not a case of Malab, again, Malab, I will stand corrected. Malab, this is not a case of yield loss. Post-harvest loss has to be reported to the bank within 48 hours. So that the insurance company can be approached and the insurance company can appoint the loss come assessor.
This coverage was for post-harvest losses.
Yes.
Yes. Coverage is for perhaps everything.
Is it?
But due to heavy rainfall, potato were totally damaged.
That means it's post-harvest.
Then it's post-harvest loss.
What we could gather the data that is regarding yield
But
loss.
you did not apply within 48 hours.
No.
But what will be the sanction for that? Let us see.
The sanction is that, what will be the negative impact?
Negative impact.
Kindly take, my lord, the appointment time frame for this is the immediate intimation, my lord.
Immediate intimation. Does it vitiate the
First of all, there has to be a policy of insurance.
Yes.
Then everything goes. There is no policy of insurance.
No policy of insurance means because they paid the premium.
They paid the premium. They paid the premium to the bank. The bank transmitted the amount to the national insurance, but the bank did not upload the proposal, policy proposal. So no,
did not pay the premium.
and the state also did not pay the premium. Naturally, state did not pay the premium.
We are on a different thing.
Yes.
We can create a legal fiction that there was a policy because they had completed their part, not making you liable, but making the bank liable to pay the.
What can be done?
We are just discussing this.
We are also, I'm also just suggestion
Even if
from
that be so, even if that be so,
I believe all the farmers, I will again stand corrected by my learned friends. All the farmers are having some loan account with the bank, subject to correction.
No, what you are thinking, Mr. Mujumdar.
I'm thinking, kindly.
No, let me finish.
Yes.
That if we deem that legal fiction,
yes,
even then they had to apply intimate within 48 hours.
Yes, my lord.
That has not been done. So what would be the effect of that?
One thing can be done, but it will be a win-win situation for everybody.
We cannot go.
No, we
after
cannot.
A point, we cannot go beyond the law, beyond the policy, and
may I just indicate to your lordship, subject to your lordship's kind consideration, because I'm concerned because that
would be compensation
of the farmers is involved.
Absolutely only that reason.
I tell you, lordship, one way, subject to your lordship's kind consideration, they are having a loan account. Obviously, the loan accounts are obviously would have some interest.
Loan waiver
of interest for that period.
Yes, my
that will be the best possible scenario in this case. So, it becomes a win-win situation.
Pay back the loan, maybe some installments can be.
Maybe installment that is there, but for that period, that will be a kind of considered as a period which would attract no interest.
But this coverage was regarding coverage was regarding the interest, the
entirety.
What happens, my lord, if the interest is waived, my lord, again subject to your lordship's kind consideration. If the interest is waived, my lord, the principal amount remains, which they are otherwise liable to pay. That they have to pay. There is no.
Even if the insurance was there, they would be liable to pay.
Well, the insurance was there, my lord. Then, my lord, whatever they had to pay, my lord, whatever the loss, insurance had to, my lord, cover that loss.
So therefore, they would not have to pay then the principal also.
No, principal is always there.
But principal is always there,
Principal
madam.
also. Yes, correct.
Principal also.
Principal.
Damage, entire damage.
Matlab, that is why it's a, matlab, what I am suggesting is a middle path.
It will be credited to their account, respective farmer's account.
It
is not only for payment of the loan, but they can use for the next crop also.
Yes.
That amount has to be credited.
My lord, one thing I have spoken with the bank officials in regard to this waiver, my lord, since my learned senior friend suggested on the earlier occasion, my lord, they said that waiver is a kind of settlement with the bank. If, my lord, there is a waiver, it is going to affect the CIBIL of all the farmers. And that will once again create a problem. And my lord, so far as my lord was asking that regarding
Better than
this time,
suicide. We say.
Matlab, civil is better any day.
Better than the
better than
suicides which are happening.
There is
my
no
lord,
doubt about
my lord,
it.
if my lord, subject to
Civil rating is going down is worse than the man going down.
my lord, about
Is better than the man going down.
my lord,
That is happening
my lord,
everywhere.
only thing is that
Look at everywhere, all parts of the
my
country.
lord, today what I humbly
Don't want
submitted that
more suicides on our name.
today what I humbly submit is that, my lord, in regard to this policy, my lord, time is the essence. My lord, it's for the farmers also, it's for the bank also, it's for the insurance company also. Deep down, my lord, if your lordship takes a view, my lord, everyone, some on the other corner, my lord, is at fault.
And we are considering, please argue on this, Ms. Rochuri, then because we are saddling you with the claim.
My lord, yes.
With the
My
compensation.
lord,
So
in
you
that
have
case,
to argue now on what
the
is the
time
effect of this non-intimation.
my lord, then
It will vitiate the contract itself.
my lord, yes, your lordship. I'll be taking your lordship, my lord, to page number 35 of the policy.
Policies
Of the insurance policy, my lord.
was that page 31. I am at page 31 now.
Page 31.
Oh, achha.
Guideline. My lord, page the scheme. My lord, will take page number 35 once. My lord, the time frame for loss assessment and submission of report. Internal page 19.
Oh, internal page 19.
Yes.
My lord, the appointment of loss assessor has to be done, my lord, within 48 hours. After the loss assessment to be completed, my lord, then after within next 10 days, then claim settlement is to be completed in the next 15 days, and maximum liability would be to the sum to the proportionate sum insured of the damaged crop area. My lord, no intimation was given within 48
Because you
hours.
did not pay the amount, Ms. Rajadri, your bank did not pay the amount. The insurance policy never happened.
My lord, we paid the amount. We did not upload the data. Well, amount was
You
paid.
had to upload the data also
Yes.
for the policy to materialize.
Yes, ma'am.
Because of your non-uploading, the policy never materialized. So therefore, the compensation has to be assessed on the entire amount. It would not be dependent any longer on their 48-hour intimation.
My lord,
If there was a policy, then they had to intimate within 48 hours.
my lord, if I may
Since
say
there is no policy now in the eye of law, what does the liability
my
come?
lord, if I may say like this, my lord, that since the farmers were also at fault, they did not intimate the bank
Their
with
intimation becomes immaterial because there was no policy. Because of your non-uploading, there was no policy in the eye of law. So your compensation, which will saddle you with the compensation which will impose on you, will be compensation for the loss itself because the policy never materialized. So therefore, you don't have to go through this route of 48-hour notice.
well, if we are going back in time, if we are trying to assess the loss and your lordship is trying to find out a mechanism, my lord, so that the farmers are not deprived, then my lord, kindly, my lord, I'll humbly beseech your lordship to take a pragmatic view on this to fasten the liability, my lord, so far as this policy goes. That bank will have their limited share, my lord, of 4.8% liability, my lord, which was there.
Oh, you say, no. The entire policy did not materialize because of your non-uploading. Therefore, your liability is for the entire matter,
My lord,
entire amount. If you did not pay the amount, or I mean, it cannot be said because the policy, see, you are one of the components of the policy. You had to pay some of the amount, state had to pay some of the amount, insurance company would. So here you did not upload, for that the policy did not materialize, which led to the entire losses.
well, we have paid.
So why should the states be saddled with costs? It's not the fault of the state. State's liability arises only once you upload.
Yes.
Yes, and my lord, the entire thing arises when the farmers intimates.
No,
They
no.
That is
Farmers have to intimate only if there is a valid policy in place. This intimation is a clause of the policy which never materialized because you're non-uploading. It's a chain reaction. You have to upload. They paid their premium.
They paid
Their
premium.
liability ended there.
Matlab they paid.
After that, if there was a valid policy, they had to apply within 48 hours.
Now the thing remains is that
They paid the premium.
they paid the
You
premium.
did not upload in
we-
time.
we-
That's why the insurance policy itself did not
But
happen.
Malad, within the cutoff that we have paid the premium. Malad, the amount was
Payment
lying.
of premium was not the only criterion.
Malad, I bow down. Malad, that is why our submission was also
Then entire
that.
liability lies on the bank for having not uploaded.
Malad, there was a technical glitch for a long
That's your
period of
problem.
time. Malad.
That's your problem.
Malad, that is
You
a
should have
that
intimated-
is
You should have resorted to other modes in intimating. Why this happened only in Kotilpur? If your central server was down, then the other districts.
It happened elsewhere also. Malad, it happened with Bank of Baroda. Malad, nationwide there was a problem. Malad, I was intimating this to your
No
lordship.
other neighboring district was uploaded.
Malad, there was a problem in Jorambati also. Malad, I got that instruction.
What about the others? You are picking and choosing only where there were problems. If it was a nationwide problem, how could the others?
Some part, Malad, there was
Must have
problem.
been proactive managers. They have intimated otherwise. You could have given the data to the insurance company. You know this affects the fate of the farmers. The insurance policy would not materialize if you don't
But so
upload.
far as
You are citing technical snag and you are not intimating. You could have contacted the insurance company on paper, asking what should we do. Our server is down. What should you do? You give us a way.
Malad, in this
You
way,
don't- you did
bank has
nothing.
paid the premium. Bank also thought that the insurance company would be asking.
You're crediting of an amount without giving the details on what account under which head.
Malad, the names of the farmers were given, Malad. The names of the farmers, Malad, the particulars of the amount given under this policy, Malad, that was given. I have
No, that
analyzed it.
was not given contemporaneously.
Sorry.
Subject to correction.
Malad, I have
That was
analyzed
given
that
much later.
Much
Malad,
later.
that was given.
No, not during that period. I am
No,
submitting on instruction.
Not during that period. I'm submitting that, Malad. Malad, the name, but when the amount was
you doing
credited,
that
under what head it was credited,
After
Malad,
1
that
or
was
2
given.
years, it was given.
Then
At least after 2 years,
be
if I am not
responsible.
wrong.
Tell us, for the insurance the policy did not materializing, who should be responsible? Farmers from their pocket, from their meager means, they have paid the premium. The bank does not upload whatever. They do it after 1 year. You want us to believe that your server was down for 1 year? PNB server?
No, Malad. For those
Why did you
15
not
to
upload in
20
time?
days, Malad.
After those days,
After the
why didn't you immediately do that?
after the 15, Malad, they have given the intimation to us, Malad. We have paid the premium, and after that,
That is the provision of their uploading.
Malad,
Yes,
I'm
yes.
showing you.
Either of
And it is there.
14
What is it?
of the rate petition.
No, in the insurance policy itself, there is a
Malad, it is there.
There is a notification.
Malad,
There is a state government notification.
That is notification dated Miller.
page 14 of the read.
November 2019 rate petition.
Read
Page
petition
14.
বলছে, read petition.
Seasonality discipline.
এই তো, হ্যাঁ।
Seasonality discipline.
ওই টেবিলটা, এই যে, এই যে।
Repetition টা কোন repetition বাদ দিয়ে সব পাওয়া এটা
WPA 122855. Scheme is in the recalling article.
Correct. This is the notification, government notification.
দেখুন আপনি যদি পারেন
Right, sir. This is a
এটা শুনে বাধা
followed by the
এফিডেভিট না দিলেন যেখানে খুলছে এফিডেভিট দেখতে হচ্ছে ক্যান Preparation. Thank you very much.
যে কোনো রিট পিটিশনে পাবে।
Sheikh Lal Muhammad Ali, page Miller 14, answer P3 Miller.
We are happy with any color.
in rate petition page
We
30.
are happy with any color. Why Lal Muhammad only? Yes, notification page 14 we have got.
That's it.
Where is it?
29 November 2019 Lordship got this date. Page 14, clause 7. Seasonality discipline will be as under. Kindly say loaning period. Lordship got it.
You have such heavy names for a loan.
Seasonality discipline
Which-
will be as under. Clause
Yes.
7.
Which one for the bank?
Now see, wheat lentil loaning period is 31st December. Cutoff date for receipt of proposal 31st December. Then cutoff date for receipt of consolidated declaration. proposal or loanee farmers covered.
Where is the consolidated?
That is the
This is-
declaration. This is the policy proposal. The bank is required to
This
upload.
is 15 January 2020 in case of
No.
analysis.
What is the consolidated declaration?
Consolidated declaration, my lord, it is like, my lord, there are.
Is it defined in? Show that. Show that.
From clause 7, read with clause 19 minute at page minute 16.
Yes, that is what we are asking.
19 is at the bottom. Yes, 16.
Yes, is correct.
Bankers will provide the details of insured farmers lease along with consolidated declaration proposal to the IAS.
It says the same
We
thing.
will also upload the relevant data in the BSC portal well before the cutoff date mentioned in paragraph 3 above. Not simply 7 above.
What is the consolidated declaration? That is what we are asking. Anyway, here bank says it had paid the premium, credited the premium, but did not upload any of these.
My lord, I'll show what we need to upload. If my lord kindly takes page number 26, that is internal page 10 of the policy, at clause 13,
Clause 13, yes.
my lord will find that the concerned branches of banks and
This is
nodal
clause
banks.
13 of what? Of the policy.
Policy, yes. It will of the scheme, my lord, it will give a clearer picture.
Yes.
The concerned branches of the banks and nodal banks in case of PACs will also collect the list of individual insured farmers, both loanee and non-loanee, with requisite details like name, father's name, bank account number, village category, small or marginal SC/ST or women insured aggregate, details of the insured land, insured crop, sum insured, premium collected wherever applicable from the concerned branch in soft copy, also for further reconciliation, and send the same to the insurance company within 15 days after final cutoff date for submission of proposal or declaration to the insurance company, and also upload the same on the insurance portal. This is what the bank required to do.
না লোনি ফার্মার্স আছে, প্রথমেই লোনি ফার্ম বোধ আছে, নন লোনি ফার্ম।
Yes, Ms. Rachid, why should we say that the entire liability should be settled with you? Whatever damage they suffered, they will now.
Whether the technical glitch, my lord, was there, that is true, my lord. It has been there. My lord, we have been trying with in different forums so that the farmers are not deprived. My lord, we never intended to
Credit
deprive
the
the
amount to
farm.
them then, whatever was in the entire thing.
My lord, to our share of percentage, my lord, we can.
Not your share. The insurance contract did not
My
materialize.
lord, the state also has a duty to pay 10%.
Only if you upload these.
My lord, then may I submit this, my lord? The amount was lying with the insurance company for more than 2 years, my lord.
They have returned it to you, they said.
The draft is ready. The draft is with
my
them.
lord,
But after the order,
We'll direct that to be returned.
We are written, we have this check.
my lord, they also had that money with them, my lord. They also never
They would
questioned.
do what with the money? Without a policy?
My lord,
The
the
insurance
insurance, the
Credited
premium
by
amount.
bank in regard to the farmers, my lord,
We can
that
appoint Mr. Chakraborty, since he's so laughing so loud that we can hear him from court. We can appoint him as a. He will calculate all the damages suffered by the farmers. Yes,
And-
Mr. Chakraborty, please come forward. We are calculating the losses suffered by several farmers. So you will calculate those. They'll make the claims before you. You give us a list.
Tender apology if I was laughing too loud. Tender apology.
So we'll do that. We'll think over this. We'll pass judgment and we'll hear you if you have to add anything. Reopening upon reopening then, because we have I have a bench court.
Lordship is keeping this matter on, my lord.
When should he tell us?
My lord,
When should
it
I?
is, my
post vacation.
2nd or 9th?
9.
9th, my lord, subject.
My lord, meanwhile, my lord, we can also, what has fallen from my learned senior
You can
friend
work
in
out
regard to
with
the waiver and my lord, everything, my lord, we can also bring back this up.
I give a workable solution.
My lord, it is.
Waiver of interest will be a win-win situation both for the farmers and for the bank. So that matter, the bank is also not saddled with the entire liability.
What would be the interest? We don't know. I mean.
Mother, that the bank can contact.
My lord, I'll
Tell
come
your
back with
lordship,
figures.
The
I'll
first
come back
thing is
with
that mother 4.85 has to be refunded to the farmer's account. A. Second is that, my lord, whatever interest has accumulated during that period on account of the farmer's account, each and every farmer's account, that interest has to be, my lord, waived straight away. And, my lord, the bank has to enter into its books of accounts that this is written off.
Lord, senior counsel appearing for the insurance company hands over a printout of an email indicating the losses suffered by the farmers in the Kotulpur area for the season BSB Robi RABI 2019-2020 on an estimated basis in general terms, comma, taking into account yield YIELD, yield losses. First of, however, comma, learned senior counsel candidly submits that this is only a general estimation of the losses and do not pertain to the particular case of the present petitioners. So, moreover, comma, the insurance scheme in question was apparently relating to other components of losses as well. For sub next para, learned counsel for the bank submits that the bank could not upload the particulars in terms of the notification dated November 29, 2019, as well as the insurance scheme due to technical glitches which had adverse effect nationwide in several branches of the banks. First up, as such, comma, there was no fault on the part of the bank in the particulars, consolidated details and particulars of the farmers not being able to be uploaded within the stipulated period. First up, however, comma, it is submitted that the premium amounts paid by each of the petitioners stroke farmers were paid to the insurance company. First up, at this next para, at this comma, learned senior counsel for the insurance company submits that even if such amounts were credited to the bank, to the insurance company, comma, without any specific particulars or consolidated details as envisaged in the scheme and the notification, comma, there was no way for the insurance company to allocate the said transfers under any particular head or under any particular scheme. Push up, moreover, comma, it transpires from the arguments of the state as well as the insurance company that the liability of the state to meet their part of the insurance scheme would arise only upon the bank complying with the requirements of uploading consolidated details of the farmers. For sub next para, since in the present case, comma, we find that the petitioner farmers had paid the premiums in due time, but it was the bank which could not upload the consolidated details, comma, leading to the insurance schemes never materializing for the respective petitioners, comma. It cannot be said, comma, in terms of the arguments of the bank, comma, that the liability for the loss suffered by the farmers would only would only be imposed on the bank to the extent of the bank's supposed contribution under the insurance scheme. For the next para, the loss of the farmers never came under the coverage of the insurance scheme only due to the fault of the bank in not uploading the details of the farmers in consolidated form within due time. First up, the effect of the same was that the insurance scheme itself did not materialize, comma, leading to the farmers stroke petitioners losing the coverage of insurance altogether. First up, next para. In fact, comma, the liability of the state to match the contribution of the bank would arise only upon the bank having complied with their preliminary liability of uploading the consolidated details, comma, which it did not do despite the petitioners having paid the premiums in time. Push up next para. However, comma, at this juncture, comma, learned counsel for the parties give suggestions as to how the conundrum can be resolved, comma, since the period of coverage of the insurance company was long back, that is in the year 2019-2020 during the Rabi season. Push up next para, learned senior counsel for the insurance company suggests that a waiver scheme can be formulated by the bank with regard to the interest payable by the farmers stroke petitioners in respect of the loans taken by them from the respondent bank. First of learned counsel for the respondent bank assures the court that she will take instructions in the meantime as to modalities by which the grievance of the farmers can be assuaged. Full stop. Next para. Accordingly, let the matter stand adjourned till January 9, 2026 for passing further orders.
Grateful, man.
Thank you.
No, it's if to be taken up on 9th. Second, I will not be there.
Not reached those matters.
Yes, second, that's why I have my other side is there also.
We have reached those matters.
My
So order can be passed.
We will
So
complete
take-
on second.
Not there. Yeah, okay.
That is why I want on second.
No, second.
You
You have to have some matters on second, Mr. Chakraborty.
some difficulty. I will not be there, or else I will not.
Some difficulties, the rest
I'll
of
not
the
be there.
non-difficulties will
I will not be there in town. That's why.
come back.
My lord, we will be seeing your lordship. I'll be seeing your lordship after the vacation. Wishing your lordship.
Thank you.
Ninth, my lord, if
Same to all of you except Mr. Chakraborty and Mr. Dutta.
So I will be here on second, my lord. I will be here.
if ninth,
Dutta এসে গেছে? No. The
But,
bench partner is waiting. We have another. Hello. Yes.
Lordship, I am not a petitioner.
A bit softer. Mr. Das. A bit softer. You're too loud. Yes. You're for the petition. What is the matter? Contempt.
Contempt matter.
Soft copy.
I like to, Lordship.
You have served copy.
Yes, on the last occasion, contempt appeared. I like to refer before your Lordship, page number.
Contempt appeared.
Yes, your Lordship. Contempt's lawyer appeared.
No. What are you saying? CPN last order was on August 20th of August.
Yes.
20th of August, we directed you to serve copy of the contempt application on them. Nobody appeared. You only appeared. You're confusing with some other matter.
Yeah, we have already served, but
Affidavit of service. We need the
service
affidavit
is
of service. Affidavit of service.
affidavit of service is lying with us.
Very good. Then you also pass the order. Mr. Das.
Lordship, I'm extremely sorry.
You should have sent it at least a scanned copy to our whatever is the official email, wherever you send. You see, Mr. Das, you have to keep in mind we are sitting. This bench is a broken bench. We have other benches. We are making time to sit for these matters only. And if you are not even ready with the affidavit of service, we are not sure of service. How can we issue a rule?
It is served already. Affidavit of service is ready.
Is anybody appearing for the other side from there? So unless we have the, if somebody was appearing, we could have waived with that filing of that.
Lordship, a day at accommodation may kindly be given.
We don't know when we'll sit. At the time of call, comma, learned counsel for the petitioner submits that affidavit that service has been effected in terms of the order dated August 20, 2025. However, comma, learned counsel for the petitioner is appearing online in virtual mode, and there is nobody physically present before us to present the affidavit of service in the court, and stroke or no scanned copy of the affidavit of service has also been sent to the designated portal of this court. Hence, comma, the petitioner is directed either to send the file the affidavit of service physically on the returnable date on the next date when we take up the matter, or to send a scanned copy of the entire affidavit of service to the designated portal of our designated link of web link of our court. Next para, the next date of the matter shall be circulated by publication in the list in advance.
Get full.
Next matter call karo. একদিন বুঝছো দিবেন রুলটা ইস্যু করে দিতে বসতে
Item number 2.
Yes,
I am for the applicant, my lord.
Section 5 has been allowed, Mr.
No, my lord.
What is the delay?
My lord, delay of 6 days.
6 days.
My lord, my application says 6 days.
What is the reason?
But we send it for
Forgot to file.
No. We send to the department for the vetting. It came.
Yes, Mr. Bhattacharya, only 6 days. They should be given a prize. State.
No, we are not objecting.
State's delay of 6 days should be counted as. Anyway, upon hearing learned counsel for the parties, comma, we are of the opinion that sufficient explanation for the delay has been given. Accordingly, can 1 of 2024 is allowed, thereby condoning the delay and preferring RVW 10 of 2024. The review application is now taken up for hearing. Yes, what is your ground?
Not only two grounds for review. Not kindly takes up the review application.
Yes, our situation.
The lordship has passed the order.
It will take only 5 minutes.
They know better than us.
It will take only 5 minutes because there is no point of law for the review.
Apparently, they have assessed that they won't be getting anything in this matter. So, yes, Mr. Samanto, it will be over in 5 minutes is very ominous for you. If you will dismiss that means. Yes, what are the 2 points?
The 2 points kindly takes up ground 2 and 3 of my.
But what has the order passed? Basically,
there was an order for acquisition, but I find they are, after your lordship's order, we find the plots are
no. The appeal was challenged. Appeal was preferred against what? So what is that? Can you enlighten us? Appeal was preferred against what? You are for this
for against payment of compensation. Against payment of compensation. Against payment of compensation, it's a order dated 14/12/2023. The lordship was
no against order of the state had preferred it.
My lord.
Oh, that's right. So that was dismissed.
Yes, appeal was dismissed by your lordship.
You are for the land users. Yes. What are your grounds for it?
The lands are border lands, my lord. That has been suppressed, and my lord, the quantum.
You are present at the time of hearing. Your appeal,
my lord.
You suppress them.
No, my lord. They suppress the writ petition, and
that's a new ground we cannot put.
Suppression is making wrong statement.
No, my lord.
Page 76 of their affidavit of opposition of their stay petition. Of their stay petition, you will also kindly see at page 76 they have annexed the order showing the Borgadars. What we have suppressed? Page 76, my lord, can you see?
Yes. This was the writ petition copy. Yes. What else, Mr. Samanto?
And moreover, my lord, the quantum of the land is wrongly
is being made.
quantum of the land has been brought wrongly described. But it's described as 23 decimal. It actually physically it's 18 decimal. We have to say the
Correct. This is incorrect.
Why
Because they obtain the possession from the panchayat. You will also can see the document. Their document, page 114 of the state petition. They obtain possession. 114.
this
One after
33
another
decimal?
wrong statement is making.
33 decimal. You are saying what? It was not 33.
no.
Gram Panchayat, Latabadi Gram Panchayat
But
document.
with the Mawar document, so it's 18 decimal.
This is wrong.
No, hold on.
This is the 2 points. No other points.
Listen to your. Sorry, Mr. Sham. You knew the fate before coming into the court. The present review application has been filed on 2 grounds. First, comma, that the writ petitioners, that the respondents had suppressed before the learned single judge that the property was under Borgadars. Secondly, comma, the land acquired was not 33 decimal as pointed out by the respondents before the writ court. For the next para, learned senior counsel appearing for the respondent before us points out that both the allegations are erroneous. From the annexures to the writ petition, comma, in particular the annexure at page 76 of the present stay application, comma, it is evident that the extracts of the records of right were annexed to the writ petition, which clearly indicate the recording of Borga in respect of the lands in question. Moreover, comma, from the annexure at page 114 of the present stay application, comma, which was also an annexure to the writ petition, comma, the quantity of land is seen to be 33 decimal even as per the communication of the Latabari Gram Panchayat to the executive engineer in question, to the executive engineer of the concerned department of the PHE department of PHE. Full stop. Next para. In any event, comma, the questions sought to be raised now are purely factual issues. Full stop. The writ court as well as the appellate court decided the matter in the present of the review applicants, and as such, comma, it cannot be said that the questions now raised either fall under the category of error apparent on the face of the record or discovery of new matter or any other ground akin thereto. Hence, comma, the parameters of order 47 of the Code of Civil Procedure having not been satisfied, comma, we are of the opinion that the review application has no merits. Accordingly, RVW
10 of 2024.
10 of 2024 is dismissed on contest without any orders to cause. Consequentially, comma, can 2 of 2024 is also dismissed. There will be no orders to cause.
By this review petition, they have kept the judgment to be operative, executed from 2024. Last 1 year has been spent by them by this frivolous application.
Now pay up. Thank you. এবার